the proceeding may come to an end. You must understand. The other side should know also what you are saying. Yes. Next, page 4, item 24 to 28.
Page number 4, item 24 to 20.
Page 5, item 29 to 37.
Item 34. I have taken consent from my lord, Mr. Rahman, since he has
34 post kar diyantu. Week commencing 6/4 na 13/4?
6/4.
Week commencing 6/4.
Oh, bless you.
ଆପଣ କେମିତି କରି ଜାଣିଛନ୍ତି କମ୍ପ୍ୟୁଟରରେ ପୋଷ୍ଟିଂ ସେ କହିଦେବେ ଅର୍ଡର କିଛି ହଉନି ଆପଣ କମ୍ପ୍ୟୁଟରରେ ପୋଷ୍ଟିଂ ଡେଟ୍ ଟା କରିବେ ୟେସ୍ ଲେଖି ଦିଅନ୍ତୁ ଲିଷ୍ଟରେ ବି ଲେଖି ଦିଅନ୍ତୁ ସୋ ଦ୍ୟାଟ୍ ଭୁଲ ହବ ୟେସ୍
Number 6.
Item 36.
ଚେୟାର ବନେଇବେ ନା ସେ କ'ଣ
Item 36, Your Lordship. I am praying for adjournment on behalf of Mr. P.K. Chand. He is not well, my lord.
sir kindly inform the other side sir
Yes, sir.
At 3
I will inform the other side.
no I am not requesting to inform him later I am not taking your dictations have you informed the other side
No, Your Lordship.
like you are concerned about Mr. Chand, you must be concerned about the other side lawyer who will be kept waiting. Please appreciate. Inform him.
Yes, Your Lordship.
କେତେବେଳେ କରିବେ
Sanction good.
ଜାଣିଛନ୍ତି
Number collect କରି sanction good.
36 ଟାକୁ ରଖନ୍ତୁ 6/4 ନା 13/4
13/4. 13/4.
commencing 13/4
Oh, blessed, Your Lordship.
Page number 6, item 38 to 40.
it's on the list
Item number 1.
next
Item number 1, my lord, I am for the opposite party. Number 3, my lord.
so anyone from Mr. Author's chamber
My lord, I will.
so I'm passing it over
My lord.
so Lenka anything to say Mr. Lenka
No.
14 years
Yes.
14-year-old man
The petitioner to say.
so I have requested Mr. Bhukta to inform
Just now
there
I will inform my lord.
Central Government Council, Mr. Bhukta, you are also there.
No, I am not central government here. I am appearing for the principal of the college, my lord.
Oh, principal of the college, okay. Your matter, item 1. Mr. A. Behra.
My lord, file has been transferred from us. Item 1.
Sir, can you recollect? Quebec transfer ହେଇଥିଲା ଜାଣିପାରିବେ?
ବୁଝେଇ କହିଦଉଛି.
Not exact date. So you have to retain the. That is how the reason you retain when you transfer a brief.
3-4 ମାସ ହେଇଯିବ.
But memo ଦିଅନ୍ତୁ ସେ memo file କରିବି. Mr. A.
SK ବେହେରା.
Mr. SK, I'm sorry, SK Behra. Chamber of Mr. Popular Author. But another A. Behra is there.
ହଁ ସେ ବି ଅଛି.
ଆପଣ ଏକା
ଆଜ୍ଞା.
ଭଳିଆ ଦେଖିବା ତ ନିଜ ଯାକ
ଟିକେ ଡେଙ୍ଗା ହବ.
କୋଭିଡ ବେଳେ କାହା ସାଙ୍ଗେ ଦେଖାଥିଲା ମୋର ଆପଣଙ୍କ ସାଙ୍ଗରେ
ଆଜ୍ଞା.
ବ୍ୟାଙ୍କ ପାଖରେ ଯୋଉ ଲାଇନ ସେତେବେଳେ କଣ ହଉଥିଲା
ହଁ ଡିମୋନ୍.
ଲକ୍ ବ୍ୟାକ୍ ବଟ୍ anyway. The Lord Counsel for the petitioner submits that the petitioner has taken away the brief after obtaining consent. Consent edition after obtaining consent of advocates on record. Appearance ଆପଣ ନାଁଟା ବ୍ରାକେଟରେ ଲେଖି ଦେଇଥାନ୍ତୁ କାରଣ ଏଥିରେ ରେକର୍ଡରେ ନାହିଁ.
ଆଜ୍ଞା.
ନା ଏସ୍କେ ବେହେରା ପଟ୍ଟନାୟକ ହେଇଯାଇଛି.
ଆଉ ଜଣେ ଥିଲେ ସେ.
Mr. DN Lekha, OP number 1 and 2.
1.
Mr. Dipti Ranjan Bhukta for the OP number 3. 3. OP number 1.
Governing body.
was presented before this court on. I'll pass the order. Registered on 30/3/2012 and 14 years is approaching to be completed. From filing of the writ application. Stop. Notices were issued by order number 2 dated 16/8/2012 by the division bench. Also, interview was passed by order dated 16/8/2012 in miscase number 5313 of 2012. Thereafter, the matter was stop. After the determination was changed, the matter was listed before on the learned single judge. Before a court, the matter was listed before a court. After the determination was changed, it modified court. After the determination was modified, the matter was listed before the assigned coordinate bench of Hon'Ble single judge on 17/9/2019. Thereafter, the matter has not been listed. Apparently, due to the efforts of the registry, the matter has been listed after more than 6 years of the last listing. The Lord Counsel, Sri so and so, files memo of date which states the following. Memo is taken on record. The matter shall be listed. In view of the above, the matter shall be listed in the in the week commencing the week commencing 6/4/2026, indicating that the matter shall be disposed of. The matter will retain its position in the list as today. As is today. Yes, next please. So file the memo. Yes.
Item number 2.
Mr. Everyone is in a hurry. Mr. T.K. for the petitioner. Marketing inspector is also your
Yes.
Mr. IGA for the opposite parties. So I'll pass that order. He's only difference is that he says no instruction. Take your seat, I'll dictate the order.
And the main arguing counsel is no more also.
CA Tanko ticket senior Tanko chamber. Appear court chile. So I am not saying anything. He is Mr. Papu. If I recognize him, he is from his chamber, but I have forgotten his TK. What is the full form of TK? Just waiting. Appearance likely. During pendency of the application, set a safe matter. The writ application was presented before this court. On 24/11/2015. Since then, the matter has never been listed. नहीं since then recent लिखो तो तापर लिखो तो 24/1/2015 the stop the matter was listed on 21/3/2016 before the deputy registrar judicial for removal of defects. Stop on the said date none had appeared on behalf of the petitioner. Stop. Thereafter the matter has not been listed. Item 1 ने भी लिख दिया उसने. The matter is listed today under the matter is listed today in the list caption आज. In the cause list caption डाल सेटा quote कर देवे for referral to special हमको quoted. है ना? इटा first line. तापर इटा लिखी दे. को last word टा कौन थे ना? Has never been listed. Stop. Para apparently due to the efforts of the registry to list older matters, the matter has been listed. Para. The learned counsel for the petitioner mentions the matter and files memo of date Sri Nanda stating the following, or which states the following. कुछ not in situation. The memo the refresh करी एवढा लिखून त्या भीतर the notice of dispute the petition starts disclosed above the petition starts. Yes.
Item number 3.
Item 3, Your Lordship, I am appearing on behalf of Mr. Rautray. Here, the order of the Learned Family Court was challenged, wherein the prayer for amendment of written statement was rejected. Your Lordship, Your Lordship, we have to take instructions on that. Your Lordship, may grant us a short adjournment with
Of
SD Rautray.
SD Rautray was presented before before on much time.
2 weeks time.
You take your seat, I'll dictate.
Oh.
On several dates. Starting with and thereafter several dates. The date of last of Miss Charvi Laurent. The wife in the marriage. So, everything up there. 2017. In CP. Visiting one there to allow understanding of the US. Statement. Right now, the state city. The CP was filed by the husband in the marriage as opposite party in the present petition. On the section 1, into bracket, I test of the union. The in the week commencing पूरे लगे हुए तो we commencing status of the city. Obtain instruction from the next just getting the present status of and the instruction. Yes.
Much obliged.
Item number 4.
May I please your lordship? I am in Lord.
Instruction never.
My lord, I have taken again. My lord, to take a short adjournment. My lord. On next week, any date may can be fixed.
This court on architecture. For the last more than 7 years that have been listed. It's called adjournment on behalf of the to enable him to obtain instruction. It's a within this position in the it's
My lord.
yes. Chachari Subila.
My lord.
Item number 5.
Item 5, listed for medicine to reference for medicine. Appearance of OP 7 notice, second time notice is issued. Perform opposite party. No. If that means a ticket sufficient, and this second time notice has been gone. Notice is minor, noting is minor, noting is. And noting is
also Sunibani that
সেটা address left মানে notice address left without instruction hence and return মানে
Reading only I am interacting. That is why I am asking that if nobody is placed by the registry,
মানে
total notice is sufficient, that is the provision.
মানে
So, because I have read something further, that's because it is actually, I have to.
মানে
In context of that, I am very happy to note that it's, but I must refer. My order should make sense.
that maybe sent to mediation so it is a
How can I send with official? Where are the other parties? Whom I will send for?
my other parties is only state মানে other parties মানে one is special value claim against
Who are?
uh,
Where are the other not trusted?
the others are sufficient others মানে there is 2 to 11 মানে 2 to 11
Sir,
মানে I'm
you are not reading the brief also.
মানে
This is the.
75
Sir, you are saying. It is the other motion.
स्टेप में मेन अपोजिट पार्ट में जो 2 to
Something it's not there. So where the opposite party is 2 to 11.
2 to 11 में 2 to 11 sufficient against all sufficient except 7 well
Sufficient.
man that is order city man order
Council appearing.
no council appearing the order is there man order is there man
Which order? Which day?
man order the sufficient order dated 7/11 to 2024 7/11 to 24 sufficient fresh notice issued
Compel bid not to read.
7/11 man
11, 24. That is sufficient.
man
Read, sir. That you do not read and then the problem.
Requisite filed on 18/12 2024 requisite filed তারপরে সেটা নোটিশ যায় মানে
What is this going on, sir?
মানে 18 Mr. Pandal on council for the appellant undertaking
Who will undertake the
office order
7/11 order টা
মানে 7/11 in view of the office note notice on all the respondent except respondent 7 are held to be sufficient
which office notes?
office note মতে কাঢ়ি আসুন
এটা শুনি আর কহিবে না
অর্ডারটা দেখুছি অর্ডার
particular, that's the hallmark of our profession. No profession of second guessing things.
মানে নোটিশ 7/11
শুনুন তো
মানে 7 মানে
আপন শুনুন
নোটিশ
সে খোলি দেখে
দেখেন খুললেন মানে notice could not be issued to the respondent on 7 due to non-file এটা 7/11 2024 7/11 2024 মানে তারপরে
তার পূর্ব
মানে 12/9 to 2024 12/9 to 24 মানে না 5/24 5/24
पांच एगार second column is the court order. बार 24
Barna choice man. Postal ID return from respondent 2, 3, 4. The postal letter received man. No notice issued to respondent 6 and 10.
6 लिखा है.
6 and the second. No postal ID.
This is the problem.
Postal ID received from respondent 2, 3, 4, 5, 8, 9, 11. After valid service kept below. Second, notice issued to respondent 6 and 10. Return answer with postal endorsement. Address is left without instruction kept below. There is Supreme decision is there. There is Hon'Ble Court decision. They did it.
तेरा काही follow होऊन सब जगह. But the problem is that suppose he has changed. It's a right answer. It's versus more. But the problem is that it's code. Now I would use a mark. 7 admission notice is to reach. You take notice after. Because any time. Have you read the recent decision of software is a right to property? On CCLRD has the individual rights as submitted to. But you are acquiring somebody's land, taking away somebody's land. Go to the CCLRD. CCLRD was not regarding land acquisition. In the interception.
Well, more precisely, this is listed for mediation. It's a state is other side.
I will record and I have to receive your permission.
And the state is the only contesting of it. No, I'm filing press. I'm file press required.
Dictate the order. The matter, though pending since the matter pending since 2022 is listed in the heading referral to Social Mediation Drive 20 Mediation for Nation. Like Mr. M.K. Ponda for the appellant. For the appellants, Sri डिपार्टमेंट क्या पार्टी करना थी
तल कोर्ट ओनली स्टेट चैलेंज ऑर्डर इज चैलेंज
डिपार्टमेंट को पार्टी करो
इम्प्रूव्ड ऑर्डर माने इम्प्रूव्ड
କହିଲେ ସେଟା ତାପରେ ଉତ୍ତର ମୁଁ ଦେଲି ନା ଯେ ତାକୁ ପାର୍ଟି କରନ୍ତୁ ବୋଲି
इम्प्रूव्ड ऑर्डर पेज 2 माने
अरे सर कौन चालची आपण ମୁଁ ପଚାରୁଛି ରିକ୍ୱିଜିସନ ଗଥରେ डिपार्टमेंट को काहे पार्टी करि नांती
କରିछ ନା
ଆପଣ
କରିछ
ଆପଣ ତଳ କୋଟରେ ପାର୍ଟି ନାंती काहे कहउछ
ଅଛି ନା ତଳ କୋର୍ଟ ଅଛନ୍ତି ତଳ ଅଛି 1
କୋଉଟା
नंबर 1
को ब्रीफ ଆପଣ ଧରଛନ୍ତି
75 to
हां को पेज रे अछि डिपार्टमेंट
इम्प्रूव्ड ऑर्डर पेज 2 माने इम्प्रूव्ड ऑर्डर
इम्प्रूव्ड ऑर्डर
स्पेशल
स्टेटमेंट देखନ୍ତୁ सर इम्प्रूव्ड ऑर्डर
special
so why is the department irrigation department he was acquired the land take the money
महानदी चित्रपड़ा
where is it आपण कोन पढुଛନ୍ତି कोन
लैंड
ଆପଣ ଏଲିଆ କୁ ପାର୍ଟି କରୁଛନ୍ତି
हां
so where is the department irrigation department
मतलब इम्प्रूव्ड ऑर्डर स्पेशल
either I'll dismiss it today
no sir
if you find that you will not improve the department I'll dismiss it today it's your choice
that part I'm
right now I'm asking so implement the soft copy right now you make amendment
permitted to
କରନ୍ତୁ ସେଟା ଦିଅନ୍ତୁ
permitted to
this is the reason the matters are kept pending. You will say in absence of so many opposite parties, refer to mediation. Requisitioning authority not made a party.
My lord.
Constitution-based decision, requisition authority has to be made a party.
Requisition manner is a government. Is a government.
Sir, you will not understand, sir. I have this is discuss all these things. I'll record, sir. I'll record your submission, but I have to reject it.
My lord,
Mr. N.K. Panda was heard at length.
I am adding
The
the
petitioner.
party man.
Sir, you are not doing any favor to me.
I am adding one.
You must understand. ଆପଣ ଆଗ ଶୁଣନ୍ତୁ ସେଠି ଲେଖ ହଠାତ୍ ଗାଡ଼ି ପକାନ୍ତୁନି କୋର୍ଟ ବ୍ରିଫରେ ଆପଣ ଆଗ ଗୋଟେ ମେମୋ ଲେଖିକି ଦିଅନ୍ତୁ କୋର୍ଟ ବ୍ରିଫଟା ନେଇ ଆସନ୍ତୁ ସେ ଗାଡ଼ି ପକେଇବେ ଫେର କୋର୍ଟ
କୋର୍ଟଟା ଅଲଗା ରଖିଛି
ତାକୁ ଦେଇ ଦିଅନ୍ତୁ
ମେମୋ
ଆପଣ ଯେମିତି ଯାହା ଆଜି କରୁଛନ୍ତି ଆପଣ ଗାଡ଼ି ପକେଇବେ ସେ ମେମୋରେ ଲେଖିକି ଦିଅନ୍ତୁ It is submitted by the learned counsel for the appellants that the matter should be referred to mediation as it has been listed under the same heading for reference. The office note put up by the registrar indicates that OP number 7, notice on OP number 7 has not yet been sufficient. On being asked, when one of the opposite parties, notice on opposite parties is not sufficient, how it can be? So, how it can be referred to the mediation for mediation? When the mediator cannot go beyond the judicial orders, issuing notice as well as regarding sufficiency of notice. The learned counsel for the petitioner, Mr. Panda, submits that since the OP number 7 is pro forma party, he need not be noticed. In response thereto, he was asked when the coordinate bench by order dated 7/11/2024 issued notice to the OP number 7 for the second time after notices were issued after the LAA was dismissed as withdrawn by order dated 8/2/2023, passed in IA number 241 of 2022. And again, ଆପଣ ତାପରେ ରିଫାଇଲ କେବେ କଲେ?
I number 56 of 2023.
ଡେଟ୍ ଟା କିନ୍ତୁ ଆଇଏନ୍ ନମ୍ବର 56 ହବ।
এটা অর্ডার নম্বর 4 রে আছে অর্ডার নম্বর 4
ডেট ନାହିଁ ତାର ଡେଟଲେସ୍ ଅର୍ଡର ଆପଣ ସେଟା କୋର୍ଟ ଦେଖୁଛନ୍ତି
ଅର୍ଡର ନମ୍ବରଟା 12/9 to 24
ଆରେ ସେଟା ତ କୋର୍ଟ ଫି ଆପଣ କୋଉଥିରେ ରେଷ୍ଟୋର ହେଲା କହିଲା ବେଳକୁ ଆପଣ କଣ ପଢୁଛନ୍ତି ପଢୁନାହାନ୍ତି ବିଲକୁଲ ପଢୁନାହାନ୍ତି ଆପଣ ମତେ ଆଟଲିଷ୍ଟ କନଫ୍ୟୁଜ କରନ୍ତୁନି ମୋର ବି ଧୀରେ ଧୀରେ କନଫିଡେନ୍ସ ପଳେଇବ
ଅର୍ଡର ନମ୍ବର 5 ରେ ଆଡମିଟ ହେଇକି ନୋଟିସ ଗଲା ଅର୍ଡର ନମ୍ବର 5
ସେଇଟା କେତେ ସମୟ ଲାଗୁଛି ସାର୍ ଆପଣ 4 କହିଲେ
ଅର୍ଡର ନମ୍ବର 5 ସେଇଟା ତ ତଳକୁ ଅଛି ଅର୍ଡର ନମ୍ବର 5
upon
court fee accept ହେଲା
for this reason only the orders are defective. In fact, after dismissal it has never been restored. upon court restoration by file करछन्ति dismissal pare when you are submitting
order number 1 ମାନେ order number 1 ହେଲା better application file କରିବାକୁ ଆଇଟା ଦେଇଥିଲି
ୱାନଟା ପଢନ୍ତୁ
this matter is taken up high court London council for the appellant press to withdraw the
English ଭଳିଆ କହନ୍ତୁ ଓଡିଆ ଭଳିଆ କଣ କହୁଛନ୍ତି
press to withdraw the IA authority to file a better application prayer is allowed IA stands dismissed as withdrawn Malad,
So better application could file hela seta sete mu pachauchi, that is how I am struggling with you.
that is a
Good application na file kale apana
it order number 4 Malad, that is
अरे ऑर्डर नंबर 4 नु आपण को दिन फाइल करथिबे ऑर्डर रे लिखा आइथिबो जे बेटर एप्लीकेशन फाइल हैला इन टर्म्स ऑफ द ऑर्डर डेटेड 8/2/23
ଲେଖାଇନି ଆଇ ନମ୍ବରଟା ରହିଛି
लिखा है मु किन करबी सेला
ଆଇ ନମ୍ବର ମୋ ପାଖରେ ଅଛି କପିଟା ଅଛି
अरे कॉपी दरकार नै कॉपी मो पाखरे सब अछि
ଆଜ୍ଞା
मु आपण पुरा कंप्लीटली प्रिपेयर भी हेछि
ଆଜ୍ଞା
बट आपण जोटा लिबर्टी नै की कहले विथड्रॉ विथ लिबर्टी टू फाइल बेटर एप्लीकेशन
ମାଲଡ଼
सेटा कोन आईएल बेटर ना एलएल कले
ଆଇଟା
बेटर आई फाइल कले
ବେଟର ଆଇ ଫାଇନ୍
चाहो रखा है गला तो मते लागला जे विश्लेषण कर चलछि तापरे
ବେଟର ଆଇ ଫାଇନ୍
Mr. Lenka and Mr. Mohanty, they will tear me apart. Yes. कौन लिखिले? LNO, the IA.
ଆଇ
After the IA number 241 of 2022 was dismissed as withdrawn. And 4 weeks time was granted in IA number, 4 weeks time was granted in the LAA number 75 of 2022 for removal of defects. अपन सेटा इम्प्रेशन दा दे दियंतु
କରିଲେ ଲେଖିଦେଇଛି
काहाको पार्टी कले
ମହାନଦୀ ଚିତ୍ରପଡ଼ା ଆଇଲାଣ୍ଡ ଇରିଗେସନ ପ୍ରୋଜେକ୍ଟ
सेटा केमति हबो इज इट एनिमेट बॉडी आपण करिवे स्टेट ऑफ ओडिशा रिप्रेजेंटेड थ्रू सेक्रेटरी और द चीफ इंजीनियर और द ये का गोटे स्टेट ऑफ ओडिशा डिपार्टमेंट ऑफ इरिगेशन का गोटे तो लिखिवे से थ्रू सुवन सो लिखिवे और लिखले yes for removal of defects. Thereafter, by order dated 12/9/2024, time was allowed. Type 12/9/2024 in IA number 56 of 2023, time was allowed for deposit of deficit court fees. But the said order stop by another order of said date. Said order no, by another order of said date in LAA 75 of 2022, the appeal was admitted. Lorded notices were issued, admitted by the coordinate bench. Lorded AC appeared and waived notice on behalf of this R1. Notices were issued to R2 to 11. ଆପଣ ବ୍ୟସ୍ତ ହେଇଯାଉଛନ୍ତି ମିଷ୍ଟର ପଣ୍ଡା you should not be. You should not. You should concentrate, keep your calm. Waves किंतु ଆପଣ भी बढिया. Respondent number 1 and notices were issued to respondents 2 to 11. 2 then TO to 11. तापर सपार लिखिए pursuant to the notices issued by order dated 12/9/2024. Requisites were filed. The office note dated 5/11/2024 indicates that 1, 2, 3 पर लिखी दियो. एटा आपण पाइबे ऑफिस नोट रे. This note order number जो लिखा है 4 and 5. Stuff. The coordinate bench has passed an order on 7/11/2024 observing thus para 2 टा कोट कर देवे. Stop para. Though the coordinate bench has not referred to any office, has not referred to the particular office note. Apparently, the above office note dated 5/11/2024 not by. Apparently, by above office note 5/11/2024, the coordinate bench was persuaded to pass the order regarding sufficiency of notice on respondents 6 and 10. The learned counsel for the petitioner, the appellant, counsel for the petitioner submits that in view of the office note that the respondents have left without instruction, the notice has to be treated sufficient, and accordingly, the coordinate bench has directed, has observed, treating the notice to be sufficient. Para. In considered opinion of this court, though there are decisions of the Honorable Apex Court like CC Alabi Haji versus Pala Peti Mohammed dealing with the said aspect, but since the matter involves acquisition of land, the respondents are से कौन रेस्पोंडेंट को पार्टी करछन जो प्रोफॉर्मा से कौन फैमिली मेंबर लैंड लूजर डिसेंडेंट ऑफ लैंड लूजर
Initially, they are claimants.
the respondents are the claimants of the land acquisition compensation.
Yes, sir. They have not.
The strict application of the principles laid in CC Alabi Haji versus Falapeti Mohammed may lead to a situation where the parties whose substantial right, like a right to property, will be affected without hearing them. The learned, accordingly, it is directed. Notice be issued afresh to opposite parties 6 and 10. ତା ପୂର୍ବରୁ ଇନସର୍ଟ କରିବାକୁ ପଡିବ 7ଟା ଲେଖା ହେଇ ପାରିଲାନି ଏବେ ଯୋଉ ଲେଖିଲେ କି ଆକର୍ଡିଂଲି ଯୋଉ ଲେଖିଲେ କି ଡାଇରେକ୍ଟେଡ ତା ପୂର୍ବରୁ ଇନସର୍ଟ କରନ୍ତୁ ଆପଣ 10ଟି ନୋଟିସ ଦେଇ ଯାଉନାହାନ୍ତି ନା ପସିବଲ ନୁହଁ ସେଟା ଆପଣ ଯିବେନି ନା ଲୋଅର କୋର୍ଟ କାଉନସିଲ ଯିଏ ଆପଣଙ୍କୁ ବ୍ରିଫଟା ଇଣ୍ଟରେଷ୍ଟ କରିଛନ୍ତି
ହଁ ତ ମୁଁ ଦେଇଦେବି
ନହେଲେ ଇଏ ଚାଲିବ ଏମିତିଆ ଚାଲିବ
ମୁଁ ଆଇ ୱିଲ୍ ପରମିଟେଡ ଟୁ ସର୍ଭ ଇନ୍ 10 ମିନିଟ୍ସ ମାନେ ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି ଆଜି ଟୁଡେ ମର୍ଣ୍ଣିଂ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେ ତାଙ୍କ ଏଲଆର୍ସ ମାନେ ଯୋଉ ପଚାରୁଥିଲି ଦେ ୱିଲ୍ ଆପିୟର ଦେ ଇନଷ୍ଟ୍ରକ୍ସନ ୱିଲ୍ ଆପିୟର ତେଣୁ ସେଟା 10 ନୋଟିସ ବେଟର ଇଟ୍ ୱିଲ୍
ଆଇ ଡୋଣ୍ଟ ନୋ ବେଟର କଥା ନାହିଁ ଆପଣ ଆଉ ଥରେ ନୋଟିସ ନେଇ ଯାଆନ୍ତୁ ଏଲଆର ତ ସବଷ୍ଟିଟ୍ୟୁଟ ହେଇନାହାନ୍ତି ତା ମାନେ ଯଦି 6
ଅନ୍ୟ କୋର୍ସ ଏରା ନ ଆଇ ହାଭ ଇନଫର୍ମ ଅଦର କୋର୍ସ ଏରା ଦେ ୱିଲ୍ ଆପିୟର
complicated situation this point will be suppose this adjudication is made appeal is held decided without hearing them this will be inherent defect up to the Supreme Court again it will be remanded
no adverse interest means adverse interest
sir that means that what you are saying you are stepping into the shoes of the respondent and saying this so you have to file that affidavit that you will take the risk
I will file affidavit
everything you say yes what is your legal strategy that I cannot assist you like this
what happens when I am
let us stop it leave it there कौन लिख ले
I am permitted to add my state of Odisha file memo.
The office note put dated 6/3/29 indicates thus out of serial number 7 Raj. Para. As a matter of prudence, notice be issued to the opposite parties 6, 7 and 10. Out here, ରହିଗଲେ କି within 4, 5, 8, 9, 11 sufficient.
सब सफिशिएंट एक्सेप्ट 7 नहीं 7 टा इतना
7 and 6, 7 and 10 by registered post by speed post with proof of delivery. With speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 7 working days.
मतलब 6
Or 5.
7 days 7 days
7 working days.
मतलब
List after S are liberty to mention. It is submitted by the learned counsel for the petition appellants that dusty service may also be permitted. Accordingly, apart from issuing notice through by speed post, dusty service is permitted. Requisites for issuance of dusty notice be filed. Steps be taken. Steps be taken for issuance of dusty notice within the say 7 days. Within 7 working days.
इस स्टेट में भी मतलब जो परफॉर्म आप रेस्पोंडेंट नो 1
जो 6 कले नहीं कि 6 and 10 से 7 टा रहिबो 6, 7 and 10 the paragraph.
स्टेट
On perusal of the cause title of the present appeal, apparently the requisitioning authority, that is state of Odisha Department of Irrigation, for which and at the instance of the state department, for which and at the instance of the state the department for which it was acquired, the land was acquired, has not been made a party. Learned counsel for the petition appellant files memo of date indicating that we shall make the State of Odisha Department of Irrigation a party. Mr. Mohanty will help you. He will tell you that who is the officer there now, because gradually what has happened, these divisions have been merged. That you must appreciate also. Maybe it is there because it's a Chitrotpara. So Chitrotpara is still there, no problem. But what like that? Seeking leave to make State of Odisha Department of Irrigation represented through kaha korchun?
Secretary
Secretary
State of Odisha represent through Secretary Irrigation and Water Resource Department.
Secretary of Odisha represented through Secretary Irrigation and Botan Irrigation Water Resources Irrigation and Water Resources. Mr. Lenka, ठीक ना भूल भाली जो पर
Water Resource Department.
खाली water resources.
Yes.
Aguru irrigation थेला.
Yes.
Department of Water Resources as OP number 12. Prayer is allowed. So the Lord Counsel for the appellant shall have liberty to implead the State of Odisha Department of Water Resources by making necessary addition in the cost title, which shall bear his endorsement and shall also be countersigned by the court master. Sister देखिए sign कला पर आपण भी sign करिवे. Yes. Para. Issue notice to the newly added opposite party number 12. आपण का copy दरकार Mr.
No.
Since copy of the application, copy of the appeal memo along with papers has been already served on the Lord AC.
No, he has made a new party, therefore copies.
नहीं आपण स्कैन कॉपी हेले हबनी हो ठीक अछि गोटे कॉपी दे परिवे से मागिले गोटे ते कर मागुछन कोन लिखले good. The Lord AC appears on behalf of the newly added opposite party number 12 and waives later extra copy of the appeal memo along with other papers be served on the Lord AC within 7 working days. Kebe chahunchodi? Actually, it's a fit case for mediation, but the problem is when you do not have the parties on board, mediation कोठी हवा से तो टाकी कर परिवे निजे निजे.
मतलब I'm permitted one line I'm explain मतलब.
So have you need to see have said about 50-60 lines?
No मतलब
So what is the difficulty 61 lines?
मतलब this is a appeal, my lord. This is a appeal. Impugned order party is here is the respondent, my lord. Some of claimant who have not given not available, they have given opposite purpose. It is for enhancement. If it will be enhanced, then others, obviously it will be.
Sir, that is not a matter of a speech. Like you are hearing speech nowadays, that is the age of speech. That is a matter of record. This affidavit you have to file that you do not want or you want them to be heard. But at least the court can say that so and so says that at his risk, let them not be heard. But you must understand a judicial order involving land acquisition, the claimants, I have recorded that who are they? They are the claimants of land acquisition compensation. The other day, Mr. Sahoo was raising this thing. In a matter, there are 53. Mr. Jenna's matter. Is he not a seasoned counsel? He also said, he also stated the same thing. And he filed affidavit that I will not take notice to so and so. So that the other side will not have this problem. For them to test against other opposite parties, what they will say, who is not on record? You are appearing for the respondent in so many matters. When somebody is there, not made a party, then what stand he will take? That you please appreciate. This has a much larger picture.
Madam.
Next time दे देबे. List in the quick commencing आज कितने है आज? अपन 10-7 दिन. बोला कितने? In the week commencing 13-4-26 under the to be listed in the list under the same heading. Yes, next please.
Item number 6.
Mr. D.N. Misra for the petitioner.
This is already covered matter. I couldn't collect the judgments, my lords. I pray for next week.
Now it is D.N. versus D.N. means it has to be.
Yeah.
Mr. D.N. Misra for the petitioner, Mr. D.N. Lenka LGA for the opposite party. That Supreme Court decision, High Court decision, that you are referring. Justice,
Saraswati Bhai, the latest.
Justice.
Applicable to Rule 9, my lord.
But why are similar orders have passed in your matters?
Not
Earlier.
that is different matters, my lord.
Those are different matters. What do you want? What do you say, sir? Notice को लेकर कुछ नहीं.
हाँ, notice of no, same it is called.
तो अपन तो reference से दियो.
My lord.
तो ता अपन कुछ नहीं. से reference से kindly give
collect,
that.
my lord. I couldn't.
नहीं. चले pass it over.
Next week, my lord. Monday or Tuesday, any day.
No, pass it. No, I'll pass the order. You give me the reference, I'll fill it up. Set up. But of course, you have to. I mean, I'm not compelling you.
And if that be wrong, my lord, I could.
अच्छा, ठीक है.
Monday or Tuesday, any day.
Prudence is always better part of the valor. DN Mr. DN Lenka लिख ले. You should, in a lightened way, Mr.
Yes, sir.
Stay at the place of the DN.
Bean square.
Yes. Learning counsel for the petitioner submits that the matter is the issue raised in the writ application is already covered by the decision of the Honorable Apex Court.
Our own court, my lord.
High Court.
My High Court, my lord.
That is WPC number 7281.
इतना अच्छी.
And you can
अच्छा 7281.
the better best.
ठीक है देखिए जो.
I have. Yes, Supreme Court order time. Especially retail, what is the benefit? No problem. Is that Supreme Court?
ଏଇଟା କୁ ସେ ଷ୍ଟାମ୍ପ ମାରିକି ଏଇଟାକୁ ଲଗେଇବେ ତା ପାଇଁ ଆପଣ ଯାହା ରିସିଭ୍ କରିବେ ଗୋଟେ ଷ୍ଟାମ୍ପ ରହିବ ନହେଲେ କୋର୍ଟ ରେକର୍ଡ ବୋଲି ଜଣା ପଡିବ ପରେ ଧରନ୍ତୁ ମୁଁ ଆପଣଙ୍କୁ 4ଟା କାଗଜ ଦେବି ଲଗାନ୍ତୁ ବୋଲି ଗୋଟେ ମତେ ମନା କରିପାରିବେନି ଲଗେଇବେ ତା ପାଇଁ
but
ठीक है
valid cover.
ले लो
Odisha versus Saraswati Bhai, 2022 2 ILR Cuttack 629.
2022
2022 Roman 2
12
ILR
ILR
hyphen cut CUT
आगे ILR को तक हाँ
629.
This is your copy sir.
Yes,
अच्छा अपन करी तो टाइप फिर दे
I'm having one. I'm having extra.
नहीं এটা kind of let us not waste this copy এটা দরকার হবে না আর্গুমেন্ট বলে দরকার হবে Mr. DN Nenka the AGS એટલે the order called actually no hard lawyer counsel for the petitioner you take your seat I'll dictate or I'll take
Yes.
some time the petitioners are physical education teachers working in different aided colleges different aided colleges they submitted that the issue involved in the issue raised in the writ application is already covered by the judgment of division bench of this court then colon state of Odisha and others versus Saraswati Bhoi and others then colon into bracket 2022 then Roman 2 ILR Cuttack 629. Stop. It is submitted by the learned AGA. Since the matter is listed for fresh admission, since the matter is listed for consideration for fresh admission, notice may be issued. Stop. Issue notice, the learned AGA upon advance copy served appears on behalf of the opposite parties. Stop. He shall obtain instructions regarding the matter being already decided. The issue being already decided in the so and so ऊपर लिख लेंगे repeat करते हुए केबे list in the
Next
next week ले तो next week
at your lordship's convenience.
the matter shall be listed for fresh admission in the week commencing 30 दिन 2024
Oblige.
देखिए ना देखिए ना डाउट আছে ভুলভাল ये पे ठीक আছে টাইপ করি পরে
Nice.
yes next please
Item number 7.
পাস ওভার করে দিন তাহলে আগে ডেট করতে হবে 7 स्पेंड कर दियंतु सिंपली पोस्टिंग कर दियंतु 7 लिखे petitioner none opposite party blank none appears for the petitioner when the matter is called to grant further opportunity list in the week commencing 30 दिन next please
Item number 8.
so PK Jana Apollo for Jana for the petitioner
The petitioner is the complainant and object party is the appeal. In one case number 17 by 2023, under section 138 of the NI Act, for bounce of a check of rupees 1 crore and 50 lakhs.
So the response of Mr. Lekai for transfer within the sessions court jurisdiction. The VNSS provides a specific provision is there that it has to be before the session judge.
From one district to another district, it is the
You want inter-district transfer?
inter-district transfer. Now it is pending in the Balangir, in the court of Balangir. But my prayer is, Superior Lordship is to transfer this case to the any court of Kotak.
Cause of action?
Compelling and
Cause of action? Cause of action could hear.
Annex 2, my lord.
Annex 2 nahi, but place. Annex 2 is not available in Odisha.
The place.
Odisha रे कौन सी जगह कौन से MD अच्छी MD हमको cause of action could arrange कला.
Given region, my lord. In the very
Reason they said, but it is a discussion in a court. It has to be legally nuanced. Before transferring any matter, our court must consider what is the cause of action, who are the witnesses, where they are available. Because on this ground, it cannot be transferred.
it will not be difficulty for the opposite party.
Sir, opposite party difficulty is another thing, but transferring a matter from one court,
And
there has to be valid reasons because it has some ramification.
I have assigned you a very good reason that in a very compelling and sorrowful situation, I have filed this application. Because
Which provision compelling sorrowful, which provision in CRPC?
wife of the petitioner is now suffering from cancer.
CRPC रे कूट इसे टाची कैंसर हेले वाइप करो
And she is
जो भी चाहे तो अवेलेबल
filed all documents.
अपन तो सुनी बेनी आओ अपन तो डिसबिलीव करा जाउनी कैंसर हेची बोली बिलीव करा गला बेली पचरा जाउची जे वाइफ को कैंसर हेले कंप्लेनेंट वाइफ होईची तो
Complainant wife.
तो
She is undergoing treatment.
ମୁଁ ତ କହୁଛି ସେଟା ଆପଣଙ୍କୁ कंप्लेनेंट वाइफ पर कन्वीनियंस इनकन्वीनियंस वाइफ कर देह खराब रे को प्रोविजन सीआरपीसी रे आई कैन इन्वोक व्हिच प्रोविजन इन सीआरपीसी आई कैन इन्वोक एंड ट्रांसफर ए क्रिमिनल केस
Valid reason must be assigned.
वेयर सर को सेक्शन पढुचंती
CRPC 407.
अब देखंतु वैलिड रीजन आप यू आर आर्ग्यूइंग अगेंस्ट योरसेल्फ
Because I
so cancer sir suffering of a disease by the wife of the complainant
that
is a valid reason court रे decide ହେଇଛି को केस रे
the husband is now
आपनकर परसेप्शन सेटा हेई पारे
the complaint has been transferred. He is now doing his job in Kotak and
सेटा कोठी जे complainant रा it is not a civil suit civil suit रे भी 24 कहला जे convenience of the parties so where 407
to go there alone living his
How
wife.
can it be, sir?
In such a
ଆପଣ ଆପ୍ଲାଏ କରିବେ ଆଇସିଡି ଆପ୍ଲାଏ କରିବେ କଟକରେ ଆପଣ ଟ୍ରାଏଲ ହେବ ଆପଣଙ୍କ କନ୍ଭିନିୟନ୍ସ
Balangire fat
ସାର୍ ସେଇଟା କୁହନ୍ତୁନି ବଲାଙ୍ଗୀର ଖରାପ କଟକ ଭଲ ଦ୍ୟାଟ୍ ସେଟା ଆପଣଙ୍କ ପରସେପ୍ସନ ଦ୍ୟାଟ୍ସ
the positive reason.
ଡୋଣ୍ଟ କୋଉ ପ୍ରୋଭିଜନ ପଢନ୍ତୁ ବହି ଆଣିଛନ୍ତି ନା ଆଣିନାହାନ୍ତି ସେଟା ଚେକ୍ କୁହନ୍ତୁ ଆଣିନା ଦିଅନ୍ତୁ ତାକୁ କହିବେ ନା ଜଲ୍ଦି ଆଉ ସମୟ କାଇଁ ନଷ୍ଟ କରିବେ କୋଉ ପ୍ରୋଭିଜନ
407.
ହଁ 407 ତ କହିଲେଣି କୋଉଟା ଆପଣଙ୍କର କମ୍ପ୍ଲେନେଣ୍ଟ ର କନ୍ଭିନିୟନ୍ସ ଆଉ ୱାଇଫ ର ଦେହ ଖରାପ ହେଲେ ହବ ସେଇଟା କରିବେ ନା ଆଉ ଟ୍ରାନ୍ସଫର ହେଇଗଲେ ଚାକିରି ଯୋଉଠି କରୁଛି ଆପଣ ଟ୍ରାନ୍ସଫରେବଲ ଜବ ରେ ରହିଲେ ତୁମର କାଲି ଟ୍ରାନ୍ସଫର ହେଇଯିବ ଫେର ଆଉ ଥରେ କଣ ହବ ତାହେଲେ କଟକରୁ ଯୋଉ ଟ୍ରାନ୍ସଫର ହେଇଯିବ ସୋ ୟୁ ମଷ୍ଟ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡ ମାଇ ଅର୍ଡର ସୁଡ୍ ବି ସଷ୍ଟେନେବଲ ଇନ୍ ଲ
My lord, very
I have all sympathy.
the husband is not in
Sir,
a situation
sir,
to
sir.
go there living his wife in such a
Sir, please don't say those things that are unfair.
hardship for
Sir, the court is asking you, you see, without interacting with you, I can't pass an order. But because I'm giving reasons, here it is not, it's a case of reasoned order. So why I'm interacting with you? The court is fair with you also. Must understand that. Because unless you educate the court in passing a proper order, no point in, hearing from you also. And with your, age and experience and stature, you must assist. Kindly find which one?
My lord, clause B of subsection 1.
ଏଇଟା ପଢିବେନି
That some question of law of unusual difficult.
ଆପଣ ଏଇଟା କଣ ଛାଡିଦେବେ ନା କଣ ପୁରାଟା ପଢିବେ ନା ଆଉ ଏମିତି କଣ ପଢୁଛନ୍ତି
Whatever it is bad.
Power of High Court to transfer.
Fair and impartial inquiry to
ଆପଣ ତ ପଢିବେନି ପୁରାଟା you miss the vital points ସବୁବେଳେ ସେକ୍ସନ ଟା ପୁରା ତାର ଟାଇଟଲ ପଡିବ।
I am reading from the beginning, my lord.
ହଁ ପଢନ୍ତୁ।
Power of a High Court to transfer cases and appeals.
Then read slowly.
Whenever, my lord, whenever it is made to appear to the High Court.
Yes,
as a fair
so
and
that is the first
impartial
condition.
inquiry.
So whenever it is made to appear to High Court, ଆପଣ B ଟା ପଢିଲେ that some question of law of unusual difficulty is likely to arise.
My
So in case of negotiable instrument act, I will say that Kotak court is better to a trial than Balangir court. Is it possible?
I am not saying that, my
So then why you are citing B?
my humble submission is that
जोटा आपनकर based
because
point
there is no other member in my family, and I am not in a
Sir, that
position
is-
to leaving my wife in
Sir,
such a
that is-
painful situation.
you are arguing as if it is a matrimonial suit. छोटो पिला
Wife is very seriously. I have
Sir, you have to file adjournment. If you can utilize ICT, court will exempt you. If at all you are filing it. Sir, those things are distance. All these things were available 20 years back. Now, have you ever traveled to Balangir?
This is 500 kilometers away.
Have you ever traveled?
I have never touched.
So that's the problem. 500 or 5,000, you do not travel. So this court suppose records that since it is 500 kilometers away, it is convenient to the complainant of Kotak, that should be some provision. You are citing 407B.
Because his wife is undergoing treatment at
Sir,
Kotak.
ସେଇଟା ଆପଣ 10 ଥର କହିଲେ ହବନି। ସେଇଟା ଆଉ ନାହିଁ ଏବେ। ବଲାଙ୍ଗୀର ମେଡିକାଲ କଲେଜ ହସ୍ପିଟାଲ ହେଇଗଲା। So you must understand when I dictate trusting you, my order should make some sense.
Man.
Otherwise, I have no difficulty. I'll start straight away. I'll read.
It should not be difficulty for the opposite party. If trial is going on,
Sir, you cannot confer jurisdiction by agreement in civil cases, much less in. So you have to answer. Have you completed your submission?
I have completed.
Correct. So where the cause of action arose?
Cause of action to Balangir.
Balangir. Who are the witnesses? Official witnesses.
Official witness is the complainant only on behalf of the complainant.
Yes. Issuance of check and all these things.
My lord.
Issuance of check and all these things. Who had issued the check? Which bank? Checkbook. Because it is a checkbook is a negotiable instrument. It is not printed by the
My lord.
bank at Balangir.
Bank at Balangir.
Balangir. So there is no reason. Suppose this question is issued that this checkbook. Let us assume you are a very good defense counsel. You will ask that the checkbook was never issued. Who will certify? Who will say that? Court cannot. You have to have the official witness. So there are so many.
Nowadays, only complaint is sufficient for the
Whatever, sir.
for the purpose of this.
The only thing I can direct that if you are making an application for ICT, availing ICT benefit, virtual court, virtual hearing, virtual deposition, VC, those things will be allowed. Considered, of course. Considered, I cannot direct. But the problem now is that you have never applied for that also. Did you apply and it was rejected?
Now, I am coming with the clause B of section 147 clause 1.
You have read, sir, 138 is I'll have to observe that since 138 Negotiable Instrument Act is pending before the Balangir court, which is law of unusual difficulty, it should be transferred to Kotak. B. It is magistrate tribunal, 138
Master trial.
magistrate tribunal. So the magistrates are Balangir, they cannot understand 138A. Cannot be correct.
Notice may be issued.
No notice, no issuance of notice. Because that is a rule getting the matter stalled. Every day we are asking the court how many cases you have disposed of. Why 130 is kept pending? Supreme Court is asking. At what stage have you been asked to appear there?
I lost valuable money because I am not in a position to travel Balangir.
Travel by train.
Wife in such a
Travel by train.
Balangir situation.
So travel by train, it is very cheap. Travel by train.
No, leaving her alone because there is no other member in my family.
Anyway, sir, that pension application will file there. I cannot be the magistrate again. Must appreciate. And I'll record to, I have to reject. If it is 2, then B, then it has to be rejected. ଆପଣ ସିଟା ପଢିଲେନି କାହିଁକି ଯେହେତୁ ମୁଁ ସେ କ୍ୱେଶ୍ଚନଟା ପଚାରିଲି ବୋଲି
ନା ନା ସେଥିପାଇଁ
ତାହେଲେ ପଢିଲେନି କାହିଁକି ସିଟା ଆପଣ ସିଟା ଆର୍ଗ୍ୟୁ କରୁଥିଲେ ବଟ୍ ସେକେଣ୍ଡ ପାର୍ଟଟା ଆପଣଙ୍କ ଏଗେନ୍ଷ୍ଟରେ whenever
that
it is made to appear to the High Court ଆପଣ ପୁରା ସେଣ୍ଟେନ୍ସଟା ବ୍ରେକ୍ କରୁଛନ୍ତି ବୁଝି ହଉନି whenever is made to appear to the court see ତ ପାଉନାହାନ୍ତି
that an order under this section is required by any provision of this code or will tend to the general convenience of the parties or witnesses or is expedient for the ends of justice.
so completely against you ଆପଣ ତାକୁ ପାର୍ଟିସଟାକୁ ସିଙ୍ଗୁଲାର କରିଦେଲେ witnesses against you expedient justice ନାହିଁ ସେଥିପାଇଁ ଆପଣ ବି ରିଲାଏ କରୁଛନ୍ତି but b 138 cannot be said that it will
I have no other witness except myself
whoever
and the other side is from UP and she has no problems.
sir, then you have to file a joint application not adversarial petition joint application you file that's a different thing
I think that she shall not have any complaint if notice is given.
keep on
She will
thinking
agree.
sir you have the advantage but the
Well,
court
if
cannot think
notice is given, I hope, I very honestly hope that she will
I am more honest than you
support her.
I am more honest than you that the court doesn't have the privilege to say that no sir this is the competition of honesty who is more honest but the court to think that the other side will agree is that it is illegal
She is from Lucknow.
is illegal mister so Jena greatest of respect if the court starts presuming about the other side then it becomes the court becomes a party to the litigation
Better convenience for her at Patak.
sir that is her petition not your petition you file suppose she files a petition to transport to Cuttack because I stay at Cuttack and Lucknow so I cannot go to Balangir that's a different thing it is your petition and the court will presume you are saying cannot be yes nothing I'll dictate the order so anything else you want to say so that is how I said that after you complete I'll ask whether which part of 407 is applicable
My request of notice may be given if she
so to frustrate
if she
this
objects
court should not be party to frustrate any proceeding this court should not be if you make a joint application that's a different thing can be
notice of the object kariyo tala
no say that's not my job that to issue notices at the instance of the petitioner thinking that the other party will agree must understand what he is saying
application is very bona fide my lord.
the order will be more bona fide
No,
order will be definitely bona fide who is saying that your application lacks bona fide you are being asked regarding the contents of law I cannot say what is there in the mind it could be possibly but then you should have that courage to file that application before that court or you courage to contact the person both of you can agree for transferring the petition and she is happy to pursue at Balangir that can be the only presumption so P.K. Jena Prafullo Kumar Jena for the petitioner opposite party blank you take your seat I'll direct I'll dictate the order the petition has been filed by the petitioner seeking transfer of 1cc number 17 of 2023 pending before the learned SDJM Balangir which has been filed by the petitioner the opposite party under section 138 of the Negotiable Instruments Act to be transferred to the court of learned JMFC into bracket rural Cuttack. It is disclosed in the application. The 1cc case was filed in the year 2023. The learned SDJM Balangir took cognizance. The certified copy of the orders passed in a 1cc number 17 of 2023, starting with 1/2/2023. Up to up to 15/11/2025 has been filed on as many as 39 dates, which shows that 39 dates. The learned counsel petitioner was heard at length. ये जो पारा पर 39 dates for लिखे हुए, the opposite party upon the petitioner gave his examination in chief as recorded in order dated 15/1/2025, and he has been discharged. That plea is not available to Mr. Jain. I should have examined the case brief. You have already been discharged.
Thereafter, the latest order I have got yesterday.
So you have been recalled.
Certified copy.
You have been recalled.
I have certified copy.
अरे
Yesterday,
सेटा चिट्ठा बरहंतुनी आपण सेटा तो देई नांती पार्ट नाही तो
by that time it was not obtained when I filed the case.
what happened आपण पचारुची. You have been recalled as a witness.
I have been chief. Thereafter, imbue was issued against her, and thereafter
सेटा ही जाई.
imbue has been recalled, and it is posted for hearing.
अतल आपणकर कोन कहतिले जे मो आपे असुविधा हो बोली कोन लिखले
Posted for hearing माने more evidence टा पुणी हो.
हियरिंग रे एविडेंस हो
I shall be cross-examined by the
तो सेटा कहबे ना क्रॉस एग्जामिनेशन हो बोली और मोर हियरिंग हो. MBW was kindly take your seat. सेटा तो नाही एतरे एनीवे ठीक अछि.
most valid.
ठीक अछि नो इश्यू. आपण पर्पस आई एम सैटिस्फाइड जे आपण जानि चंदी कोन लेटेस्ट स्टेज दैट यू हैव बीन कॉल्ड फॉर क्रॉस एग्जामिनेशन. लेकिन thereafter MBW was issued by the said order dated 15/1/2025, order number 34 dated 15/1/25 against the accused person. Latest position कौन है? Execute है ना नहीं है?
Helen is surrendered and the return bail.
को date? At this stage, the learned counsel for the petitioner produces certified copy of the order sheet. Photocopy of which is retained. And a photocopy is very there. अच्छी फोटोकॉपी दे दियो. फोटोकॉपी अटेस्टेड करी दे दियो. एटा रखि लो सर को दियो. कौन लिखले? हाँ सर्टिफाइड कॉपी ऑफ अटेस्टेड फोटोकॉपी इज रिटेन. On 9/10/2025, from the order dated 9/10/2025, it's apparent that ଆପଣଙ୍କର କଣ ସିଲ୍କ ଶାଢୀ ନା କଣ ଏଇ ଜିନିଷ?
Sorry, madam.
କମୋଡିଟି ଟା କଣ? ତ ଟ୍ରାଞ୍ଜାକ୍ସନ ହେଲା, what is the consideration for this check? Any idea? Anyway, that's not exactly necessary, but I just want to understand this. The idea is से काहे मागितले? What is the due? Anyway, leave it there. ଯଦି ପାଇବେ କହିବେ. The opposite party, the accused person has appeared through the learned counsel. The learned STGM Balangi stop para kariki. During pendency of the said case, CLMC number 4677 of 2025 was filed before this court by the opposite party accused, that's accused. challenging the NBW 15/1/25. Stop. The said order was set aside by order dated 13/11/2025 by this court in serial MC number 4677 of 2025. And photocopy that. The final receive kariye taku. Directing payment of cost of rupees 800 to the Advocates Welfare Fund of the Local Bar Association of Palangit. Upon said conditional order being complied with, order dated 1/12/2025. The appearance of the petition, the appearance of the opposite party was acknowledged and he was released on bail. As earlier, she was released on 1/8/2026. So the Lord left. It has deviated. To take I'll take some time because factually, if I keep it, then so that photocopy. See, he knows see. He was after the learned counsel has completed his submissions, he was on being asked which provision he relies on to seek transfer of the application, transfer the 1cc case. He submits that the reason for seeking a transfer is bona fide, as the wife of the petitioner is unfortunately suffering from cancer. And the provision he would rely is section 407 into bracket 1 into bracket D. Small b. Before Bhubaneswar, small b. For convenience of reference, as the said provision would have bearing on deciding the issue, is reproduced herein. 407 ta up to C jaye, quote kar dega. The result of the said section indicates that it has to be made to appear to this court, to the High Court, as provided in 407 into bracket 1 into bracket small b, one the English one. That some question of law of unusual difficulty is likely to arise. The present is under section 138 of CRPC. The 1cc case is pending since 2023 and has been and has been listed on several occasions before the learned SDJ, who has passed as many as 40 orders till 1/12/2025. As has been noticed above, the complainant has been examined in chief and has been discharged. It is submitted by the learned counsel for the petitioner that as per his instruction, he is to be cross-examined. In considered view of the court of this court, applying the principles principles contained in section 407 of the CRPC, since repealed and substituted by pari-materia provision contained in BNSS 2023. bracket closed. Would not lead to a conclusion. The convenience of the witness has to be looked into by the court, by this court, for transferring a petition which is in the advanced stage of adjudication. So the petition, as it has been stated by the learned counsel for the submitted by the learned counsel for the petitioner, the petition may be bona fide, but it should also serve the ends of justice. Accordingly, prayer made in the application is rejected. Rejected and the petition is disposed of. However, it is directed. The petitioner, the complainant petitioner, if so advised, shall make appropriate application before the JMFC Balangir for utilization of ICT facilities. So, if any such application is made, the same shall be considered and disposed of by the court in session in accordance with law.
I will pardon, man.
Please.
You may be targeted.
No. Jana, please don't project me that I deliver.
Sir, make a prayer, not
Association. Here it has been created by the smokes aspect. Though the constitutional bench has directed the High Court not to issue orders targeting cases. May be paid out, the High Court is targeting cases if they should not. The reason, if a single one, what is mandate, Shinai Act 1920, prior to 23, this particular the anxiety of me, your concern is right, Mr. Jain. But whether the court can do that, because somebody has come to court, so should expect. I am sure is very clear on this. Because there are several cases pending, so somebody coming to High Court for expediting this matter and the first one or other matters. That's super. A very strong language has been used by Supreme Court, if that has been solved. And that is in a case. The concern actually is to noted that somebody is incarcerated due to lack of trial. But there are so many persons under trial. So how can one person be trial? The other case is pending and the court is not taking up. You can make it, but then there is appropriate. But when other cases are pending, or respective like a parties are the parties to the space and liberate the expense of this problem. Yes.
Item number 9.
May I please, my lord? Let's dash. Well, it's item number 9. Well, the petitioner is the husband, my lords. My lords. Plus, the petitioner is the husband, my lords. He has sought for transfer of CRP number 2 of 2026 that is pending in the family court Jagasipur as to the court of family Judge Kendrapada. Let's CRP is for maintenance. Plus 144, one of the BNCs. Yes, may I read?
Yes, please.
Well, it's a order for maintenance of wives, children and parents. If any person having sufficient means neglects or refuses to maintain, A, his wife unable to maintain herself, or B, his legitimate or illegitimate child, whether married or not, unable to maintain itself, C, his
So
legitimate.
anyway, sir, you in your case it is 144 1A, wife claiming.
Mileage.
No.
Wife and children.
So which section of this BNSS provides for jurisdiction?
145, 1 mileage.
Can you read?
Well, it's 145 procedure. Proceedings under section 144 may be taken against any person in any district.
So can we stop there?
Mileage.
The first is general, any person in any district.
Mileage.
Yes. Where
Mileage subclause A, where he is or
he is or.
where he or his wife resides.
So now, where the wife resides and where you reside.
Mileage. Currently, the wife is residing at Jagatsinghpur.
So then, how this court can override 145B, which is perimetry to 126 1B?
Mileage.
This has not been amended.
No, mileage. But mileage may kindly see the
So any precedents on this? Apart from my lord seeing, because I have to override that statutory provisions.
because there is clause C.
Territorial jurisdiction, of course.
Mileage may see. Mileage, where he.
Acha, you are reading because C, so that C has to be followed.
Mileage.
Is it yours? That has to be rejected, mister.
Mileage, where both.
I'll record it and reject.
Mileage, I am saying.
So when B and C are separated by or, you are reading it as and.
No, mileage, that is to be
So if
constituted.
it is or, then please stop, because whenever, I can easily reject your submission without, discussing with you. But you must know that if you are making a submission which the court records and rejects with reasons, you must know. That is what I am telling you. A is separated by A or B or C.
Mileage.
Now you are reading B and C together.
No, mileage, C is a separate clause.
So what about B I am asking you?
That's
A and the opening statement. Opening. Proceeding under 144 may be taken against any person in any district
mileage.
where his wife resides. So what is your take on that? What is your submission on that?
Well, so my submission is, mileage, these three provisions, A, B, and C, mileage, they provide that where the proceedings is maintainable. Mileage, in the present case, mileage, if that is filed in Jagatsinghpur, mileage, there is threat to life of the present petitioner.
So why you have lost the FIR?
I have not.
Because somebody, have you read about Kalidasa? Do you read Kalidasa? Kalidasa, when he did not have the blessings of Goddess Saraswati, as it says, because it's a lesson for me at least. So he was chopping off the tree branch where he was sitting. The lady who has filed claim petition, she is threatening your life. So it will be a written statement also. We will bring to the notice of the court because it is a matter sub judice.
Mileage.
So have you brought to the notice of the court?
Yes, I have averred in this present
Court. I am not the magistrate.
that mileage I have.
So please appreciate that when you make a. So then now the question is, I would simply listen to you and pass, no difficulty. But the whole effort of interacting is that you should know that you are making a legally nuanced submission.
Mileage.
Your first submission is that 144.1, 145.1, B and C should be read together.
No, mileage, they are separate.
They're separate. Oh, okay.
Mileage.
Fine. Then you say that you have a life threat to your life at Jagatsinghpur. First threat for theory. So then obviously if I record that, then to justify my order to transfer from Jagatsinghpur where it is unsafe and Cuttack is safe, I have to give reasons. Because for you, Cuttack is safe. What are the reasons? Then prima facie material should be there. Prima facie material is the best place is that, like Kalidasa, if the lady is threatening you, then it is recorded by the court.
So
And now there is suppose now there is a hallucination, delusion, you know that these concepts. You must have read, you seem to be, I mean, so I suppose he has a delusion or the wife has a delusion. So that will not amount to judicial intervention.
that is one
That is how you will find there is no such provision in CRPC, IPC, Nagarika Suraksha Samhita, this Samhita where third perception is treated to be offense or any kind of credence is given. It is all based on evidence. Or at least prima facie material has to be there.
that is
You can if you build a castle in thin air, so it will fall apart. And judicial scrutiny is always based on particular aspect, particular facts. That is the hallmark. The whole process is based on particulars of sections, of facts, provisions, contents also. The pleadings contents are there also.
my lord.
One has to be very particular. So you bringing your third perception to this court doesn't help you.
That is one of
And the jurisdiction is not also conferred on me. Please appreciate that. So no case, mister. No case.
another ground is there, my lord.
Please. Never be hesitant to make your submission. But always try to appreciate what is being discussed.
My lord.
Because by the next case or the next 10 case or whatever, you will be in a better position to articulate.
My lord. Let's
Because these questions you should have asked to your client. He comes running to you that I am threatened by so and so. Then can you prevent any harm to him? You cannot. Physically you cannot. As a lawyer you cannot also. He has to follow the due procedure of law for protecting himself also. Yes, another submission.
Well, sir, divorce proceeding has been filed by the husband in Family Judge Kendrapada, my lord.
Look at 19. Look at 19. Divorce proceeding E5 is 145(1) ABC with 19 of Family Courts Act, Hindu Marriage Act. So that is a complete separate jurisdiction.
My submission is the wife is coming and participating in Kendrapada, my lord, right? So the case has.
So where is the proviso in 145? Whenever a proceeding is pending, initiated by the wife, and she is participating, then the 125, 144 has to be filed there. That kind of interpretation has to be legally substantiated.
There is no provision for.
So then don't make such a prayer.
It's on the ground of convenience, my lords.
Which at 145 one. Just now, convenience was argued by Mr. Jenna. I mean, very senior and seasoned counsel. Again, the parties, plural, it is plural. I don't know what you are saying may be correct, that she has a strategy of harassing you by lodging different cases. That has to, that has to be interpreted in terms of law. And 144(5) is 145(1)(a) is very clear. And there is a purposive interpretation is that the distressed lady where she stays, is there only. Yes, anything else?
On that.
So please take your seat. I'll just dictate the order. The application by the husband in the marriage has been filed before this court. Seeking transfer of the C.R.P number 2 of 2026 filed by the wife in the marriage. What? 125 रे बूथ रे जजमेंट अछि बोले छै ना नहीं पाइबे ना पाइबे के लिखंतु The said CRP has been filed before the learned judge, family court, Jagatsinghpur. By the wife. And the minor girl child, born from the wedlock, is it about 3 years? The address statement in the cause title of the petition of the wife is 22 Dekhi. Both are of village Joychandrapur, Purada Lekhiwe. In the present application also, the address statement of the wife has been indicated along with the child born from the wedlock, which is also identical to the address statement of the wife in the petition. The learned counsel for the petitioner was heard at length. On being asked under which provision the petition filed by the wife under 145(1) of the PNSS into bracket 2023 will be directed to transfer to the Court of Jurisdiction at Cuttack, he refers to Section 145 of the BNSS 2023. Particularly 145.1 into bracket 1 into bracket small c. As the said provision has bearing on the issue to be determined in the present application. The section is reproduced herein. Section 145 is reproduced herein. The objection register भी दे देंगे. Total the code दे देंगे. On being asked, since 145(1)(b) and C are separated by or, whether for applying the provision contained in 145(1)(b), C has also to be read. It is fairly submitted by the learned counsel for the petitioner that since the clauses in subsection 1 of 145 are separated by or, they have to be read individually. To substantiate the claim seeking transfer of the application, it is submitted that it has been stated by the petitioner in the present application that he has a threat for his life, towards his life at Jagatsinghpur, and for which he seeks transfer. In response to the said submission, on being asked whether the petitioner, who is the opposite party before the learned judge family court, has ever brought the said threat perception to his life to the notice of the court in session, and oblique or whether he has lost any FIR or any other method to protect his life in accordance with law. Comma. It is submitted by the learned counsel for the petitioner as per his instruction no such steps have been taken by the petitioner. In view of the legislative mandate, as would be evident from the objects and reasons of the section 145 BNSS, to 2023, which is pari materia with section 126(1) of the CRPC, into brackets since repealed. The wife and minor child should have the choice of filing their application seeking details, as it is a benevolent provision enacted under section under Article 15 into bracket 3 of the Constitution of India. Into brackets, this is on the letter. Justice Krishna has Krishna, Justice Krishna has read it. Para. In view of the above, the prayer made in the application is rejected. The application is disposed of. If further directed, the petitioner, if so advised, shall make application in accordance with law to the learned court in season of the matter for granting him facility of ICT. से paragraph लिखी देवे पूरा अच्छी से टाइम इटा भी आगे जजमेंट भी पूरा अच्छी आपको मने पड़ो stop है ICT such as virtual hearing, virtual deposition, stop. Upon filing of such application, the same shall be dealt with by the learned court in season of the matter in accordance with law, and appropriate orders shall be passed.
Let's I may be permitted moments.
Yes, please.
Your Lordship had directed that it will be from Jagatsinghpur to Kendrapada. Your Lordship had directed
Kendrapada. Okay, sorry, that point. Thank you. It is submitted that. Upon CPT key file
husband, present petition.
The husband has filed CP number
315 of
2023. My lords, invoking section 13(1)(a).
My lords.
Invoking section 13 of the Hindu Marriage Act 1955, seeking a dissolution of marriage, which is pending adjudication before the learned judge Kendrapada. Upon चाहते जगतसिंहपुर टू केन्द्रापड़ा ना कटक
जगतसिंहपुर टू केन्द्रापड़ा
केन्द्रापड़ा सेटा कटक केमती गोटे पसिगला मते केन्द्रापड़ा हम इन कंसिडर ओपिनियन ऑफ दिस कोर्ट इटा जोटा सेटा पछरे ऊपर को इंसर्ट हो बुझ पाछन्ती एटा इन कंसिडर ओपिनियन ऑफ दिस कोर्ट द चूजिंग ऑफ ए प्लेस ऑफ लिटिगेशन. The territorial jurisdiction is defined in section 19 of the Hindu Marriage Act. Whereas the territorial jurisdiction for initiating a proceeding under section 144 of BNSS 2023 is provided in section 145 of BNSS. The jurisdiction as well as the context of both the statutes, objective of not context, objective of both the statutes being different. Filing of CP at one place by the husband cannot be a ground to transfer the application filed by the opposite party wife, which is in terms of section 144, 145 into bracket English one into bracket small b. Rest of the matters after recess. Yes,
They come 24 masters.
24.
Yes.
You seek adjournment. 23 they have sought that 24 you are seeking.
I'm 24. The date has not filed counter.
It's a simple adjournment. Because if you want any judicial order to be recorded, please wait or instruct any of your learned colleagues. You did not wait. If I understand, your submission is that since it is after notice matter, pleadings have to be complete.
Yes,
But they can take note too. Can take note.
some of the date. Some of that.
Joda date suggest karibe.
As your lordship please.
I please for today only. It's not, and as your lordship please is not available there in the calendar. Either you wait for your chance or you get sick adjournment. And I'm avoiding to pass orders in adjournment so that is saving time.
2 weeks.
Lordship, in the first half of the morning, your Lordship has been informed that in item number 23, the petitioner has expired. I have informed the counsels appearing for the opposite parties and I'm filing a memo also to that effect.
Okay, but you will not be there after recess because the order needs to be passed there. If you have any difficulty, you can inform any of your friends.
I'll do that.
2 weeks after 22 weeks.
24 is count in adjournment. Counter the annual question.
State is not a party. 25.
24 week commencing 13
Yes.
but no order.
Yes.
No order. Whoever say the Sir Rohibani will coach it actually. He has some difficulty. So because he says that counter is not there, so pleadings have to be completed.
Yeah.
Pass over कितना रहता है? को जाएगा Nine dictation दिया होगा. 10 sir आपन को रक्षा. So Manoj Bihari Das.
Yeah.
Yes, please.
This is a revision against the maintenance award passed by the Land Judge Family Court, Jashpur.
So secure the decree. For entertaining your application, you have to secure the decree. Yes. If you do not want to pay your wife in the marriage,
Yes,
you deposit it, get the interest.
my lord, my prayer is before this honorable court that my income has not taken into account of.
Very well. That's a very good ground to challenge that. What is your written
I'm
statement?
just getting 7,000 rupees.
Sir, what is your written statement?
It is all through in my evidence. It is
Sir, don't make a speech all through my evidence. I'm asking you, you are in a high court challenging a order.
yes,
So where is your written statement?
the annexures are there.
Sir, not there. Go to the page, paragraph,
Okay.
which you could not impress the lauded trial court.
Yes.
Don't make it a matter of joke.
At para 11, in
Page, sir.
page 6 of the
You are struggling and making me struggle also.
page 6 of the application, it is
No, sir, written statement. You are smiling when you have to show written statement. You should not.
no.
You have made it truly a joke.
No, my lord.
Where in your written statement you have stated your salary and how the lauded court has dealt with that?
The statement presented before the court under the statute.
Sir, kindly show that.
No, that has been not been annexed, but that has been.
I may look like a joker, but
No,
this is not a joke.
So, my lord,
Our conversation is bordering. I don't know what the kind of conversation we are having in court.
no, my lord, that very statement.
Sir, I have to record. Sir, this is a serious proceeding. Whatever stated, I have to reproduce in my order. If you are not serious in challenging the order, so it be. But it cannot be a matter of speech and this kind of smiles and exchange of.
Actually, I have not.
Sir, when you are saying that in your written statement you have stated so, that has not been considered. The court will ask to see that. Then you do not have any answer.
No.
You are saying through and through.
Yes, that is at page 22, my lord.
Page 22 is not readable. You have to type it out. But anyway, why you have stated that your monthly income is 7,000?
Yes.
So you have to prepare the case before arguing before High Court. Maybe the court is a joker, but still you have to prepare.
No, my
There is
lord.
no presumption.
No, my lord. In my statement of accounts, I have already.
Sir, straight away put there. You have been saying that for the last, today a little bit early, I thought that I will save time, I am wasting my time. After food, I thought that immediately I should, because some detailed judgments were passed in the first half. So let us be serious actually. We are being watched. We are being watched, sir.
Let it come 2 weeks, next week, my lord. I will satisfy. Everything is there. I will place it.
Sir, it has to be placed today, sir. Today is the best day, sir.
Sure. I have to check it out. The problem is I have not gone through that very portion of the things. Actually, in which portion?
Sir, can you look at page 27? I will assist you. I was a lawyer, sir. For reasonable time.
Okay.
But we look at page 27.
Sure.
What's your name? Rajakishore Rath.
My client is Rajkishore.
Look at page 22. Your learned junior is not also equally, prepared.
It is 5,000 here.
Para one file.
Yes.
Name Rajkishore Rath.
This is the last.
Yes. So then kindly turn to, it is in continuation. Go to straight away page 27. Sir, instead of blabbering something to you, look at the court. Ask your junior to sit down. I will assist you. Kindly take your seat. I will assist both of you. So kindly mark page 27.
Milord, that is there.
Milord is not there. Read just paragraph below 5. Self-employed, professional, business persons, entrepreneur. 1, 2, just go through up to end of page 6. Everything is crossed.
Milord.
So I cannot entertain. Your application. Scope of revision has been. You were the conducting counsel before the trial court.
No.
So you should have asked the learned briefing counsel these questions. Revision is guided by certain principles. Even based on the evidence, if it comes to the High Court, the High Court feels that this different conclusion can be taken. Still it cannot. Judgment by Honorable Justice Chief Justice Deepak Misra by Supreme Court.
But Milord, it has been taken into consideration in the improved judgment.
The problem is that you have to what was the written statement has to be before this court.
Yes.
This court cannot have a separate view. That's not the scope of revision. Anyway, you will get time, but you must ask these questions and answer so that we make a meaningful discussion. Mr. Manoj Bihari Das for the petitioner, opposite party blank. Petitioner husband in the marriage is before this court seeking revision of the order dated 12/12/2025 passed by the learned judge, Family Court Jajpur, in criminal proceeding number -216 of 2023. I'll grant you adjournment. You take your seat. I'll dictate the order and grant you adjournment. Or you want dismissal today?
Below?
Do you want dismissal today?
No, no.
Okay. Okay. Under section 19 into bracket 4 of the Family Courts Act 1984, read with section 438 and sections plural kar diyo. So 438 and 442 of BNSS 2023 stuff. By the said judgment, the learned judge, family court, by said judgment, बार बार 25 लेक्चर नहीं होगा. The said judgment, the learned judge, family court, has allowed the application filed by the wife in the marriage under section 125 of the CRPC. Yes. Granting maintenance for an amount of rupees. Any further disturbance? No, I will pass the agenda now.
I am not telling anything.
So please kindly take your seat.
Yes.
If you want to stand, you like standing, no problem. You have your choice. Call लिख ले. For an amount of rupees 8,000 per month from the date of application, that is 5/10/2023. To challenge the document, challenge the judgment, it is submitted by the learned counsel for the petitioner that the learned judge, family court, has not taken into note of the monthly income of the petitioner. In response, learned counsel was asked to show the written statement filed before the learned judge, family court in the proceeding wherein the impugned order was passed. He refers to the page 22 of the petition annexure 3 series. To submit that the said document, the affidavit indicating assets and liability would indicate the monthly income of the petitioner. The learned counsel was further asked to specifically find out from the relied upon document which at page 25, paragraph 3, 25 of the petition, paragraph 3 indicates that monthly income is 7,000 per month. At paragraph 4 of the judgment, the learned court has noted the submissions of the statement, noted the statement of the wife that the petitioner herein, husband in the marriage is serving in Dhanagadi block as clerk, earning rupees 30,000 per month. Apparently, the said submission and assertion of the wife has remained unrebutted, and the income of the petitioner at the rupees 30,000 per month and rupees 1 lakh per annum from the agriculture remained unchallenged before the learned trial court. But since in view of the judgment rendered by the Honorable Supreme Court in Rajneesh versus Neha, the amount directed to be paid to the wife in the marriage is to be treated as money decree. So since the petitioner has opted to challenge the said amount, the learned counsel for the petitioner was asked, what is the amount due, how much he has paid, if any payment has been made, and for sustaining the challenge, how he will, whether the petitioner will secure the decree, secure the amount awarded. So the learned counsel for the petitioner seeks for adjournment. Accordingly, the matters are listed in the week commencing 23 ଆପଣ ଆଜି 9/3 ରେ ଅଛନ୍ତି 23/3 30/3 ନା କଣ ଚାଲ କରୁଛନ୍ତି?
Yes, let it come on 30th.
The week commencing 30/3. The matter shall be listed listed for fresh admission. Yes, next please.
Item number 11.
Petitioner wife seeking transfer of 1 CP proceeding from the Learned Court Family Judge Baleswar to Senior Civil Judge Uddala, my lord.
Mrs. Das, you don't have power here.
My lord, I have. Yes, ma'am, I have.
Yeah, 11 upon technically. Move to upon 11 technically. Sorry. 11. I'm sorry. I have opened 10.
No, my lord. 10.
This digital has this immediately when you shift. Mrs. A. Das for the petitioner. Yes, please.
My lord, on the ground that 125 proceeding is pending before the Learned Civil Judge Baleswar, and after getting notice from the Senior Civil Judge Baleswar, the husband has filed this CP proceeding for dissolution of marriage under section 13A of the Hindu Marriage Act. The CP proceeding is a counterblast of the 125 proceeding.
But if you go through section 19 and section 19 of Hindu Marriage Act and section 9 of CPC, it is very clear that he being the dominus litis, he will file it at each place. If you want participation through VC or anything, and wherever you appear, there will be amicus curiae, because in Family Courts Act, usually the lawyers are engaged as amicus. So that part is also, I mean, and more so if you are getting 125 maintenance.
My lord, in maintenance also he has not paid anything. 128 proceeding has been initiated.
You prosecute that. In fact, 125, both the scenario, 125, suppose he seeks transfer. You should pursue your 125.
No. In 125, it has been awarded, but he has not paid. And 128 proceeding has initiated against the husband, my lord. In that proceeding also, he is not. He is also avoiding the process, my lord. And now
that 125 has been completely frustrated according to you.
Well, and 128 is also pending against. The arrear has not been paid till yet.
You can notice and seek adjournment.
Well,
but I am not very encouraging of this shifting cases, which takes a lot of time and adds to the burden. I mean, it is not achieving any purpose unless there are some cases where it is required.
well.
And then 19 has to be read that wherever the wife resides.
Well.
The problem is that neither section 9 or section 19 of Hindu Marriage Act can be interpreted like that. 24 again, convenience of the parties.
Yes.
That cannot be read as convenience of a party, and that to the wife only.
Any party, madam.
Of the party. So court has to draw a balance. And if 19 is a bar, suppose, let us say that the husband has filed an application which section 19, he could not have. 19, then that augurs in your favor. In the sense, since you will be registering the CP, the first point It's not maintainable territorial jurisdiction.
Right.
That's it.
Let
I mean, use resistance to the CP
yes.
to take notice.
Mal.
Let us see. Appearance like opposite party blank. You kindly take your seat. I'll dictate down.
Next may try also.
The petitioner wife in the marriage is court seeking transfer of CP number 534 of 2025. Pending before the Lord Judge Family Court Balasore. To be transferred to the Court of Lord Civil Judge Senior Division Udola. Had Lord Counsel for the petitioner. She submits that the wife is in distress. She has filed section 125. She has filed petition under sections 125 CRPC. Along with the minor child born from the wedlock aged about 3 years before the Honorable Judge before the Lord STJM at Udola. The said case is pending before the Lord STJM Udola. Para. तो এটা আপনার ফাইনাল হয়েছে না ইন্টারিম হয়েছে kindly sit down in the said pending proceeding interim maintenance has been awarded so the husband opposite party in the said case has preferred to remain in default and non-compliant default of the amount awarded by the court. Stop. Thereafter, petition seeking enforcement of the amount of maintenance. Petition under section 128 of CRPC was filed, which is pending. It is submitted from the conduct of the opposite party. Husband, it appears that instead of complying the order in 125, instead of complying the order passed in the 125 petition, section 125 CRPC petition, he has adopted a strategy of filing a CP for seeking the divorce, seeking dissolution of marriage.
Yes.
Dissolution of marriage, solemnized between the parties. Issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within 5 working days. List after SR. Liberty to mention. जो लिखले issue notice आज होची के तना तारीख returnable date be fixed to 6 April 6/4/2026. List in the week commencing 13/4/2026. तापर लिखिबे आइए 49 of 2026. Issue note, hard noted counsel for the petitioner. Stop. She reiterates her submissions as noted above. Issue notice as above, along with the petition. Accept one set of process fee as well as postal requisites. List after SR, liberty to mention. In the as an interim measure, it is directed that the CP number 534 CP number 534 of 2025 pending before the learned judge family court Balasore shall be adjourned to a date beyond 20/4/2026 subject to convenience of the learned court in season of the matter. Upon a prayer being made by the petitioner hearing, who is the opposite party in the said proceeding. Stop. List in the week commencing, actually, 13/4/2026. Liberty to mention. Next, transfer of which matter?
Next, item number 12 is also being the wife. She is seeking transfer of CP number 4 of 26, which is pending before learned family judge Baripada to civil judge senior judge Hon'Ble. On the same set ground that she has filed 125 proceeding, which has been initiated against the husband, and in 125 proceeding, notice has been issued to husband, and nothing has been, or no order has been passed.
Baripada and Udola are very proximate.
Well, approximate. It is 70 to 80 kilometer distance only.
Same order ta kari debe, the correction kare pade. Ethre award hi to likha hai ni ki 125 re award hela pore 128. See line ta rahibani. Right? See interim order ta share. To say appearance, say same corner, same date, returnable short, list in the 13, adjournment beyond 20. Yes, please. Similar cases, list order so that. But you have to first find out them. Basic case ଆପଣ କୋଉ କେସ୍ କାହା ସାଙ୍ଗରେ ସିମିଲା ଯାଇପାରିବେନି ଯେତେବେଳେ ଆଧାର ତାକୁ ମିଶେଇ ଦେବେ ତାପରେ ଆଉ ଗୋଟେ ପ୍ରୋବ୍ଲେମ.
Item number 30.
Yes, Ms. Das Mahapatra.
May I please
Ms. Pranayani Das Mahapatra for the petitioner. Yes.
The petitioner filing this case for seeking transfer of the civil proceeding number 450/2025 from the Court of Family Judge Puri to Judge Family Court Cuttack. As because my lord, the petitioner filing a 125 petition at Family Court Cuttack, and after getting notice, after receiving the notice, the
same as
and also priority, my lord, given to the opposite party.
That decision, actually, what you have said,
my lord,
that day I read those decisions.
My lord.
But that reference is not there. How it is done?
My lord,
both the decisions I have found out. Anyway, these are facts are better.
My lord.
You are saying a one like Mr. Das's matter, 125 file.
My lord.
Award is made.
No,
but after your notices are issued, so he files a CP.
My lord.
Are you sure of the facts?
My lord.
Well, so the same.
So I have annexed the CP case as annexed 3.
No, I have marked it. I have marked
my
it.
lord. And also annexed 1.
So you take your seat. I'll just dictate them.
Oh.
Petitioner wife in the marriage is before this court seeking transfer of that day you cited one decision. So those two decisions have
Air 2002 C3B my lord. Air 2002 Supreme Court 396.
But
Susmita Singh versus
correct, sir. That madam, that paragraph where the court has discussed the facts, you must understand. Supreme Court has 142 power. High Court doesn't have. And High Court is suppose High Court can pass a order following Supreme Court. So High Court has to apply those reasons. Like recently in a one matter, Honorable Justice Bindal, after 44 cases are filed, he grants direct cost of 10,000 to each party, husband and wife, and the direct dissolution of marriage. So in High Court, we have reached up to 37 in one matter. 37 cases are filed against each other. So good for the lawyer community. So can I pass that order? 5,000 cost, say 1,000 cost on each, the marriage is dissolved. Please appreciate. So now suppose I want to pass that kind of an order. I have to apply the reasons. So that is how I was seeking your assistance, that if I'm going to apply these reasons, because in many cases, actually the wife is facing difficulty.
My lord, wife is in distress.
24 says distress, no, convenience of the parties. CPC says, section 9, it has to be entertained by any court. Section 19, very specific, where the husband is there or their last resided matrimonial home, sorry. After marriage, where they resided or where the marriage took place. If you apply those tests, then it is very difficult to pass an order that as per the convenience of the wife, it has to be transferred. So there I seek your assistance. On the next day, not today, because today already that your facts are different. Now let us assume there is a matter for final hearing, like after notice hearing. I will pass an order for transferring of the matter. On the face of section 19 and section 19 of Hindu Marriage Act, section 19 of the section 9 of CPC, I have to direct transfer. Then I have to apply those principles laid down by Supreme Court. So there I seek your assistance. Like if I now settled that it's a money decree. Enforcement, civil imprisonment, detention, confiscation, all those things. So it's kind of a women's empowerment, because those Rajneesh versus it has noted 7 years. The case has been filed. The wife comes after the courts for 7 years. Nothing is happening. 128 power is given. Arrest power is there. 125(3) is there. Still it is not having.
But my
and wherever notice is issued, then the order is not complied with. Some cases 10 years, 15 years, 6 years. In TRPC, after notice, I have in my recent adjudication, I have found Lord Counsel. I still remember the name also. 6 years, nothing has happened because this court has so court granting issuing notice has a purpose with an objective. So, but by simply issuing the notice, the matter gets frustrated. And now, in several cases, apart from Rajneesh versus Naya, the court has expressed concern that matrimonial matters, maintenance matters should not be kept pending.
And here,
in some cases, there is an extreme case. The wife herself gets a transfer and gets the matter stayed.
My lord.
So anyway, so this is what I see. I am just apprising you that whenever you argue that matter that day, so please prepare on those aspects.
And
anyway, let us utilize the time enough for the general discussion.
Matter maybe stay as because
adjournment. Stay. You can't ignore a lawyer also. You engage a lawyer, whoever he or she may be.
My lord, petition, say Kotak to Puri is 100 kilometers. It's difficult to the part of the petition.
I cannot record as 100 kilometers. So that's another thing. Anyway, you take adjournment. CP number 450 of 2025 pending before the Learned Judge Family Court Puri. We transfer to the Court of Learned Judge Family Court Kotak. The CP number 450 of 2025 has been filed by the husband in the marriage under section 13 into bracket 1 of the Hindu Marriage Act 1955, read with section 7 into bracket 1 into bracket 4 of Family Court Act, seeking decree of divorce. Your divorce. Stop. The marriage between the parties was solemnized on 9/7/2023. Stop. It is submitted by the Learned Counsel for the petitioner that she said that the wife has filed CRP criminal proceeding number 182 of 2025. Yes. 182 of 2025 under section 144 of BNSS 2023, seeking monthly maintenance at the rate of 20,000 per month. The said application was filed on 22/10/2025. It is submitted that in order to avoid the payment of maintenance, the opposite party husband in the marriage has adopted the method of filing CP, seeking divorce. So, it is submitted that the wife is distressed. She doesn't have financial ability to prosecute the matter. She pursued the CP at Puri. Puri ru kottak chahunchନ୍ତି na at Puri. जो CRP लिखिले 182 of 2025 filed at Kotak.
Family just Kotak.
144 टा कोठी फाइल करछन्ती 144 BNSS.
Family court Kotak.
The CRP number 182 of 2025 under section 44 of BNSS has been filed at Family Court Kotak and is pending. Take your seat. Issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within 5 working days. 5 दिन दे परिवे. 5 working days. Returnable date be fixed to 6 April 2026. The matter shall be listed in the week commencing 13 April 2026. तापर लिखिबे IA 47 of 2026. Had learned counsel for the petitioner. She reiterates her submissions as noted above. Issue notice as above. Accept one set of process fee as well as postal requisites. Stop. The returnable date and date of listing shall be as indicated above. In the interim, it is directed that the CP number so and so, pending before so and so, shall be added to a date beyond 20/4/2026 by the learned court insists upon a prayer being made on behalf of the opposite party in the said case, in the said matter. Beyond a date लिखिले, अब date 20/4 beyond 20/4 ना 20/4 subject to the convenience of the learned judge. Yes, in season of the matter. Yes. Yes, next.
Item number 14.
Mr. Arijit Misra for the petitioner.
The wife as petitioner is before my lordship, my lord, for transfer of a petition filed by the husband under section 9 of the Hindu Marriage Act. under Annexure 1 in CP number 99/25.
Yes.
From the Court of Learned Family Judge Bhubaneswar to the Court of Family Judge Kendrapada.
Yeah.
And my lord, the 144 application is pending at the behest of the wife before the Judge Family Court Kendrapada.
That was initiated prior to the CP or after?
Yes, prior to the CP. This was issued and thereafter he
Same.
I don't in the habit of taking.
Okay, no problem.
Is being pronounced.
No problem. No, for anything I'll ask you, definitely. The petitioner wife is before this court seeking transfer of the CP number 992 of 2025. Wife in the marriage section. Seeking transfer of the CP number 992 of 2025 from pending before the Learned Family Court of Bhubaneswar. 1-2 किछि नहीं मतलब Family Court 1-2 जो अनुमान ने भेजी
ना किछि खाली Family Judge Bhubaneswar
from the Court of the Learned Judge Family from the Court of the Learned Family Judge Bhubaneswar to the Court of the Learned Judge Family Court Kendrapada. Kendrapada. Stop. The CP number 99, that's the said CP. The said CP was initiated by the husband in the marriage under Section 9 of the Indian Marriage Act for seeking restitution of conjugal rights. The CP was filed on date jana paduni?
Na date ta jana padunai.
Acha. They submitted that.
More date touch.
The petitioner wife has filed application colon देख लिखी हुई criminal proceeding 192 of 2025 under the provision of section 125 of CRPC seeking maintenance before the Learned Judge Family Court Kendrapada, and the said application was filed by the wife on
1/12/2025. That is page 19.
On one Vishnupriya Das.
Again, toward the verification as well as affidavit, Lordship may kindly have a glance.
18-26 ଲେଖା ହେଇଛି
ନା 18-2 ଟା ହେଲା କମ୍ପେୟାର କପି ଯୋଉ ଦିନ ଆଣିଛି ଏଠି ତ ତଳେ ଲେଖା ହେଇଛି
ତଳେ ଯୋଉଟା ଦେଖା ଯାଉଛି ଆଚ୍ଛା ତାପରେ ଚଢି
the fact stated above are true to my best of knowledge and I
on 1/12/2025
ଆଜ୍ଞା
on 1/12/2025 it is submitted that the wife seeking maintenance is under financial distress. And she will have further difficulty in managing the matter at Bhubaneswar. Stop. The Learned Counsel refers to the cause title of the plaint filed in CP, which indicates that the place of residence of the wife in the marriage is at the village Choti, Gram Panchayat Derabis, PS Nikiri, District Kendrapada. It is submitted that it would be difficult for the wife to attend the matter at Bhubaneswar, staying with her parents at village Choti in the district of Kendrapada. CHH ଆପଣ ଦେଖି ଲେଖିଦେବେ issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within five working days. Returnable date be fixed to 10th of April to 8th of April 2026. This recommencing, the matter shall be listed in commencing 20/4/2026. यहाँ पर लिखिए IA 65 of 2026. Our learned counsel for the petitioner, he reiterates his submissions as noted above. Stop. Issue notice as above along with the petition. Accept one set of process fee as well as postal requisites. The returnable date and next date of posting would be as directed above. Then in the interim, it is directed that the CP number 992 of 2025 pending before the Learned Family Judge Bhubaneswar shall be adjourned date 27/4/2026. Upon an application being made, upon a prayer being made for the said purpose by the petitioner herein, who is the opposite party in the said matter.
Number 15.
Yes.
Please, your lordship.
So Rautre,
My lord.
so Vikas Kumar Rautre,
My lord.
for the petitioner.
My lord, your lordship directed last occasion to produce the certified copy of my lord, the petition challenged the two proceeding, my lord. In this case, before your lordship.
Just kindly go through the last order, page 22/2026.
My lord.
Read para 5, para 4 onwards.
Lord, the said petition under section 125(2), CRPC has allowed by the order dated 13/7/2019, directing the opposite party petitioner herein to pay sum 2,000. To the said amount 2,000 has been sought to be enhanced to 10,000 per month.
Read further, sir.
It is submitted by the Lord and Council for the petitioner. The parties have agreed and filed a petition under Section 13 of the Hindu Marriage Act 1955 for dissolution of marriage and mutual consent. The said petition is registered as CP number 194/2022. Court of Law and Judge Family Court Jagatsinghpur. It is further submitted that the petitioner husband in the marriage has paid 2 lakhs to the opposite party wife pursuant to the agreement between the parties. Being asked whether the said aspect has been brought to the notice of the Law Judge Family Court, giving the details of payment made to the assist the claim of the enhancement, and if any order has been passed on the said aspect, the Law and Council for the petitioner and has adjourned to obtain instruction.
मते कोटारे सेटा ऑर्डरटा आंसर को देखिबे ना आपण जदी कोटा रिक्वेस्ट ना निजे पढिबे ना मु कोन पढि
मैं ऑर्डर
रे सर को दियंतु ଅଛି ଆପଣ ପାଖରେ
ମାଇଲ ଅଛି
ତାହେଲେ ସେଟା ଆପଣ ସାର୍ଟିଫାଇଡ୍ କରି ମତେ ଫଟୋ ମତେ ଦିଅନ୍ତୁ ଆଟେଷ୍ଟେଡ୍ କରି ଦିଅନ୍ତୁ ଯଦି ଆପଣ ସେ ପ୍ଲେସ୍ କରିବେ ଏବେ ଦେଇ ଦିଅନ୍ତୁ ଦେଖିବା ଯଦି ଆପଣ 5-6 କୁ ସାଟିସ୍ଫାଇ କରୁଛନ୍ତି ନା ଆଗ ଦେଖନ୍ତୁ
ଆଜ୍ଞା ଅର୍ଡର ଡେଟେଡ୍ 1/9/2025
ହଁ
advocate for the petitioner file evidence affidavit. Lord and advocate for the OP file objection. Copy of the original case record is not tagged with the case record. Issue letter to the district record.
How does it help you, sir? How does it help you in view of the order, specific order passed by this court? 4, 5, 6. 4, 5 is the context. 6 is the result. How does it help you 1 and 25?
My lord. See.
Because you are challenging the order.
The proceeding, my lord. And
Yes, execution case आपण register କରୁଛନ୍ତି ଚାହୁଁଛନ୍ତି stay ହେଇଯିବ ବୋଲି
ଦିଟା CMA as well as execution.
ଏକ୍ଜିକ୍ୟୁସନ ଷ୍ଟେ କରିବା ପାଇଁ ଆପଣଙ୍କର ସେଥିପାଇଁ ଆପଣ ଯୋଉ ଆୱାର୍ଡ ହେଇଥିଲା ଯେତିକି ଆୱାର୍ଡ ହେଇଛି so that's a money decree. Supreme Court has said and it is followed. Now you say that 2 lakhs you have paid.
Suppressing this fact, he has filed 2 cases.
So fair enough, sir. Suppression before which court?
The learned in Judge Family Court.
So where you are bringing this to which court? I'm not the learned Judge Family Court, or I doubt that I'm also the learned Judge Family Court.
I had
Suppose now something happens in Odisha before some court. The High Court will take note of that, or that court will have to take note of.
I have already bring the matter.
Where is that?
Annexure 4, my objection. Last thing, put a question to me whether you have bring the matter objection to the knowledge of the learned trial court.
Not objection, upon recording देखिପାରିବେ. I have some difficulty in forgetting. Why I say so? If you re-argue the matter, everything comes back to my mind what you said and what I said. The problem is that suppose you are thinking that since some days have passed and no. I mean that's a standard approach. It has happened.
Sir,
no, sir. You are not slowing, sir. You are thinking that I am finding a fault with you.
Well, Lordship, I have a
This has happened. I can tell you. Not in High Court. I mean, this court, other courts also. I know a specific instance of another court. That's simply adjourning. But the problem is that if you are registering, you see, I am going by the first principle. First principle of execution. Basic principle. So that I'm spending little time. It is not required actually. You say that you have paid 2 lakhs. That is a very good defense in execution. So you have to produce evidence before the trial court that I have paid 2 lakhs. You said, though I have not recorded, the other day you said that there was an agreement, meetings between the parties, the family members, seniors and other gentries. They settled at an agreement of 2 lakhs. But they backtracked after payment of 2 lakhs. That is your instruction. I hope I remember that day. That's that day's conversation. So now what is your job? I said that it is very simple also. Because you have to tell the court, I have given this money. Court will record that. They may dispute it, but ultimately the court has to give a finding on that. If the court does not entertain you to payment of 2 lakhs, which you have said as you are saying, then you have a case to come here. To tell that, do I have paid 2 lakhs? I have produced the evidence before the court. But if I make the order very specific, para 6, then you will be misunderstood because you have heard that theory of
my lord, para 7.
So ସେଇଟା ଆପଣ ଦେଖିବେ କେବେ execution file ହେଲା ଆପଣ କେବେ payment କଲେ. At least I have been reiterating that you show before the court from the day I have taken up this assignment. So that there will be no confusion on date. So ମୋତେ ଦେଖିବା ପାଇଁ କହୁନି, date ମୁଁ ପଚାରୁଛି.
My lord, on 30/7/2019 with a direction to the petitioner to pay ₹2,000 per month. On 23.
One second. ଆପଣ ତ calculate କରିବେନି, ମୋତେ ହିଁ କରିବାକୁ ପଡିବ. ଆପଣଙ୍କର 2,000 per month.
ଆଜ୍ଞା.
With effect from
30/7/2019 ରେ ହେଇଥିଲା order.
अरे order date of application. Again that is a mistake. Date of application is Rajnish versus Neha. Application date केबे?
30/7/2019.
ଏଟା 15 ହେଇଥିବ। ନା ଆପଣ डेट दिया है नहीं
डेट ऑफ जजमेंट ऑफ 30/7/19
ठीक है 30/7/19 সেটা ଆପଣ ପାଉନାହାନ୍ତି କି ସେଟା ପେଜ 16 ରେ ଅଛି यार you should be faster than me page kindly read order 2000 from the date of passing of this order ठीक है 30/7/19 2000 ଟଙ୍କା so ଆପଣଙ୍କର 30/7/25 ଯାଏ ହେଇଗଲାଣି
ତାର mean time 13 ବି ଫାଇଲ ହେଲା ସେଟା ସପ୍ରେସ ହେଇଗଲା
ଆପଣଙ୍କ ମାନେ you are neither here nor there. Sir, you are not getting it. If that order merges with the 13B order, there is no such order. You are saying that 13B has not worked out. But you have made the payment. 13B order is ki?
No, payment by virtue of the 13B minor. That the payment
13B କରିଛନ୍ତି କି
2 lakhs କରିଛୁ ବା
ସେଇଟା ଆପଣ କାହିଁ ସେଇଟା ଫେର 13B ରେ order ହେଇଛି ଆପଣ 13B ଟା
dismiss for default
dismiss for default ହେଲା
ଆଜ୍ଞା
So 13B रे जदि dismiss for default ହେଲା but आपण कहबा कथा जे client has paid 2 lakhs so सेटा आपण देखंतु
annexure
कोन लेटर दिले तो जेतो पछले आपण उठौचंती मते कागज बढौचंती annexure दोचंती
annexure 2
डेट सर केबे देले आपण 2 लाख
21/9/2022
21/9/2022 से डिटेल्स कोड लेक्चर ए जो प्रेजेंट एप्लीकेशन रीड पिटिशन रे ए कोर्ट रे आपण एफिडेविट देछंती पिटिशन डोंट यूज योर स्पीड ऑन योर विद्या ओडे बहुत किछि
पेज 4 In view of the above settlement, the petitioner has already made payment 2 lakhs.
डिटेल्स सेटा देखैतिला आपण तथा भी बुझी पाले आपण पेमेंट रा एविडेंस देखिबे आपण पार पढलेनी पेमेंट एविडेंस को बुझचंदी
सेटा
पेमेंट एविडेंस होची जे आपण मेथड रे देले
मोड ऑफ पेमेंट 1 lakh ड्राफ्ट 1 lakh कैश
कोड सेटा तले 2 लाख आपण को 1 लाख कैश आपण कोड सेटा देखैछन
13 रे हिया जल्दी
13 बे अगेन पढले आपण बटन 226 रे हाई अछंती आगे तो सेतोला बुझौछि जे आपण 13 फेसिंग डिफिकल्टी बिकॉज़ देयर इज नो ऑर्डर इन 13
2 lakhs टा
अपन ना कौन भूली होली सर
विकास कुमार
Mr. Rautre, sorry, Mr. Rautre, if there is an order in 13B that recording that you have paid 2 lakhs, she has received 2 lakhs, सेटा देखिबे
13B पिट
सेटा अपन 13B टा डिसमिस होता सेटा ऑर्डर हिची की
ऑर्डर मिल से एडमिट करी आगे
सेटा पूछनु डिसमिसल करे that court has to take note or cognizance of that court passes a order सेटा अपन जो the court order passed that by so and so has filed application indicating that so and so order has been paid. So that is your case is that 13B was dismissed for default, but still then you have made the payment. So instead of again going back to 13B, you show before this court the evidence on record what you can produce, how much money has been paid.
Yes.
So that about every time what you are doing, that you are charging
mode of payment amar 1 lakh draft 1 lakh
what was the mode of payment answer kon hobo tale if I ask you what was the mode of payment answer kon debe
1 lakh cash 1 lakh
did the question no gote answer kimti hobo first question to produce evidence of payment second question what is the mode of payment two questions cannot have to one answer ଆପଣ ଯଦି ଦେଇଛନ୍ତି ସିଧା ସେ ଏଭିଡେନ୍ସ ଏଠି ଆଣନ୍ତୁ ସିଧା ଆଫିଡେଭିଟ
13B ଫାଇଲ କରିଛି ତାର ସାର୍ଟିଫାଇଡ୍ କପି
13B not a family judge 13B affidavit if the court has
admit
ସେ जो admit କରିଛନ୍ତି ସେଟା court order has admitted so and so has admitted that she has received ଦେଖନ୍ତୁ କେତେ ଥର ଆପଣଙ୍କୁ ବୁଝେଇଲି ଆପଣଙ୍କର ପ୍ରୋବ୍ଲେମ କଣ ହେଉଛି କହିଲା you have converted the into a conversation ସବୁବେଳେ ପେଜ ଉପରେ କାଗଜ ଉପରେ ଯାହା ଡେଟ୍ ପଚାରିଲେ you are 13B ରେ ଯଦି ସେ ଆପଣଙ୍କର
ସାର୍ଟିଫାଇଡ୍ କପି ଅଛି
ସାର୍ଟିଫାଇଡ୍ କପି ଆଡମିଟ୍ ଆପଣ ସେଟା ଏଠି ଫାଇଲ କରିବେ ନା ମୁଁ ଆପଣ ପଚାରିଲା ପରେ ଆପଣ ତାପରେ କରିବେ ଆପଣ କୋଉଠି 13B ରେ ସେଟା କୋଉଠି ଲେଖିଛନ୍ତି କି जे 13B ରେ ତାଙ୍କର ରେକର୍ଡ ହେଇଛି that she has admitted have received
and जे
after understand 13 months nothing survives you are completely under you are barking of the wrong tree Once 13B has been dismissed for non-prosecution, it goes forever. Only thing is that suppose an order was passed, maybe that will proceed. Strict sense that will not, because it is a dismissed application. Court not for opinion. Now you are saying in 13B, there was a agreement and you have paid her 2 lakhs. So now again go back to the order.
My lord, he had suppressed on judgment of apex court, suppressing all this fact and this petition.
Sir, House of Lords is there. I have difficulty again removing case law also. Your problem is that you are not sure of your facts. You are arguing off track, not understanding what the court is asking you. Even a detailed order is passed. Just again read. So now even I am giving you opportunity, if I paid 2 lakhs, so it be. So show the evidence before this court in the writ petition. Our answer is, my lord, 13B he has suppressed and filed this 125 application. 13B was filed.
26/2022.
26/22 13B फाइल है डिसमिस के बेला
5/8/2024
5/8/24 आगे किबे फाइल है 125 डेट
एजुकेशन 100%
किबे 125 है एग्जीक्यूशन मेंटेनेंस केबे फाइल है केबे ऑर्डर है केबे एग्जीक्यूशन फाइल तापर नेक्स्ट इन डेट अपन था डेट को पड़ेले हजार 2015 पेंडिंग थिला सीएमए फाइल है 2/2025 व्हिच इज क्लियरली आफ्टर 5/8/2024 आपण asi हाई कोर्ट सपरेशन आपण सिटी 8/5/24 डिसमिसल परे सीएमए 2/2025 रे कहवा कथा जे समथिंग हैज बीन सप्रेस्ड और समथिंग हैज बीन पेड
मतलब
सेटा आपण कहला देखंतु सेठी कोड देखेले प्रॉब्लम नथिंग शॉर्ट ऑफ दैट यू आर गोइंग इन ए टेंजेंट सी आगे सप्रेस कर देले से केस रे राजी 13B यू हैव द मेजर हर्डल इज दैट 13B हैज बीन डिसमिस्ड बाय कोर्ट
सेथरे थिंग एविडेंस
हैव यू चैलेंज दैट इज इट नॉट बाइंडिंग ऑन यू 13B is it not binding on you? It is binding on you. But you can say that in 13B there is a recording of the fact that she has received. सेटा आपण मु आज परे ऑप्शन अधघंटा लागू छी जे से ऑर्डर ता कोठी जदी से रेकॉर्ड करिसंती ते 13B she has received so and so amount सेटा हले देखातु
13B
after dismissal in fact I should not, but anyway I am taking a lenient view. Dismissal for how can I go into the terms of the settlement and payment? I should not, because the court having jurisdiction has rejected it. You must understand 13B there is a judgment by this court that 13B power cannot be exercised by High Court. It has to be by the trial court. Anyway, that's more of academics. Apanakar simple jinsa, you have to be specific in your assertion that I have paid 2 lakhs so that
already
I would get known to these questions you should ask. What is client interviewing? Why client interviewing is an important aspect of profession and practice. That is how a lawyer is making a submission in 2-3 minutes because he masters all the facts. When you are challenging execution on the ground that though an amount has been paid that has been suppressed from the court, and the court is proceeding. The next, immediately you have to harp on the point that this amount has been paid on this day. No court. You see, you are not begging anything favor from the court. You are seeking assertion of a right of a citizen, of an individual. That should be the approach. Is it that if I like, I will grant? If I do not like, I will not grant? But I should have the basic material with me. That should be your approach also. So that suppose I do not adhere to your right prayer in interfering, you challenge it, because I have shown to the court that I have paid 2 lakhs. Of course, the first question is that whether you have shown to the executing court the payment of 2 lakhs. At least now, if you see show it here, that may help you. Obviously, if you do not show to the executing court, how this court will come? But there is a way out. But now, to start with, you are struggling there actually. You must show that evidence. The learned counsel for the petitioner notice a certified copy along with a photocopy of the order sheet in CMN number 02 of 2025. In fact, there is as such no order against you. You are just panicking. Which order is against you?
Order has not been
So in fact, the curiosity kills the cat. You have spoiled your case coming to High Court also. Now, any observation, the learned judge will think that why the High Court is in session. Because you have said that in 144 that matter of 2015, there is a pending case. Then there is a case in CP where 13B you have paid. All those records he has to go through and pass a order. But after he has adjourned the matter, you have brought to the High Court.
No, man, I have filed an objection by the annexure for.
So let him pass a order. I have explained you that let the court pass a order on that on your objection. Then at least he will be able to know that he will argue here.
My lord, after filing of my objection, the learned court will is proceeding for evidence.
It will.
For which I have challenged. He has not take consideration my objection.
It has to. Otherwise, it is misconduct on part of the court. After filing of your evidence, you have filed not your which order you are saying it is proceeding for evidence?
My lord. Orders.
Date ta kaun tu?
My lord. 27/10/2014. On that date. 1925, awaiting for original one receipt of next date, no petition, receipt of original record of on receipt of original record CRP 144 the case record is up to date, the case record CRP number so and so is received attached to the case of put of date fixed. 11/25 learned advocate petition of present or advocate OP file time petition. The ground stated there in had prayer is time put on for hearing.
Yes.
There were 10/25 learned advocate for the petition file member stating the petition wants to adduce evidence of Pujanga Circuit Court. Learned advocate OP file time petition on the ground stated therein. Therefore, time is allowed subject to payment of cost of 500 only. Add on the memo from both sides. The memo is accepted. Put upon 27/10/25 for payment of cost and hearing. Next 27/10/25. Learned advocate petition file Hajira. Learned advocate for OP take no step and absent on call, no cost paid. One witness is examined. Cross-examination nil and discharge. Learned advocate petition file so close memo. Evidence from the side of the petitioner is to put up 25 evidence of OP and payment of cost.
So what mistake can High Court can find out from this order? What mistake the magistrate has done? Because the High Court is High Court and the magistrate will do whatever.
No, I have bring the knowledge of the London trial court in my objection. This is the
state ki advice करथिले High Court advice करथिले आपण ट्रायल कोर्ट रे देबेनी स्टेट आपण advice करथिले you are the conducting counsel.
Trial
Then what is this form of proceeding in a matter? One proceeding is nil and discharged.
Cross examination recall पड़िला cross examination
ଯଦି recall ହେଇଗଲା ଆପଣ ଫେଭର ହେଇଗଲା you are agreed by which order? ଆପଣ ଯଦି ଦେଇଛନ୍ତି ଆପଣ ପ୍ରୋସିକ୍ୟୁସନ ପଚାରିଲେନି ତାଙ୍କୁ ଯେ ଆପଣ 2 ଲକ୍ଷ ଟଙ୍କା ପାଇଲେ ଉତ୍ତର କଣ ଦେଲେ
ନେଇଛନ୍ତି
ତାହେଲେ ଆପଣ ଏଗେନ୍ଷ୍ଟ କୋଉଠି ଡିସାଇଡ୍ କଲେ ଆପଣ ତ ସାଙ୍ଗେ ସାଙ୍ଗେ ହାଇକୋର୍ଟ ପଳେଇ ଆସିଲେ ଆପଣ କୋଉ ଅର୍ଡରଟା ଆପଣଙ୍କ ଏଗେନ୍ଷ୍ଟ ଗଲା ଯେ you are agreed by which order? Court taking up a matter and proceeding with the matter can never
challenge the proceeding.
Cannot be. By no merit, Mr.
My lord, by virtue of this,
Sir, you are
multiple proceeding has
Sir, any execution file has to be entertained. There is no provision. That is how you are struggling with any provision of any code or any statute. That the court will not, rather the mandate. Have you read, Rahul sir?
No, my lord.
Read it.
My lord, the opposite party
If you do not read, this court shall help you.
And conflicting the orders of the court.
Nothing. There is
multiple proceeding.
Sir, ଆପଣ multiple proceeding କୋଉଟା କାହାର multiple କହୁଛନ୍ତି?
File କରୁଛି
କୋଉଟା କହୁଛନ୍ତି?
CMA also and
execution arises out of a 125 proceeding,
my lord,
which is maintainable. 13B you are saying is dismissed. So where is the multiple proceeding?
Suppressing multiple. He has it's a petition.
Suppression is not. If here time, where by which order is against you?
My lord, no order has been. My lord, he has filed multiple proceedings.
Nothing, sir. Enough.
Conflicting the orders of the court.
I will simply record I will record all your submissions and pass out. Leave it there. Enough indulgence is there. And you should understand first that you are officer of the court.
My lord,
you will strictly follow the law. You talk to, you explain to client that much. That is your job.
If that opposite party will disclose the fact, I have no case. I will not.
Sir, it is not a question of a cover up. If you want to rely on some, you want to rely on something, you rely on that. Leave it there. Nobody is putting a cover before here that this is covered, that is covered.
No, I am not in.
So leave it there. And you have been given sufficient chance.
No, he will file suppressing fact and conflicting.
That is your requisition.
That document says.
Yes, I will record.
I am not orally.
So that is
so that my lord.
He has suppressed. So I have asked you that what he has suppressed the payment. You will say that payment has been suppressed. So why are you shown? Nothing.
I was next the 13B petition.
13B petition.
Yes, sir. Which he put his signature and
13B, you have honest, you have said, I will record that.
He put his signature, advocate, he attested his signature, then filed, then admit and conciliation. Now,
in fact, I have remembered everything. Everything is for you. Okay, so you kindly take your seat.
Okay.
Or if you are like standing, then you stand, no problem.
No.
Like Mr. Mishra said that he likes standing. Mr. Vikas Kumar Rautre, the learned counsel for the petitioner is heard at length. With file this with a memo. Or a memo kori dei diyo beta. I will accept photocopy. Keda diyo. Keda memo likhi dega. But the copy ta diyo. Ago likhi para 1 2 repeat करते हैं 1 2 3 5 3 4 5 repeat करते हैं of order dated order number 1 dated 23/26 same. यहाँ पर लिखो तू and this is part of the order here. the same paragraph of the application. The learned counsel for the petition and its memo. Memo is same.
Memo sir बस चार्ट लिखते हैं ठीक है नहीं नहीं मेमो चल
Of date, it will be satisfied copy of the order. Orders, order detail will take one, will be looked at. In some cases, of the rest of the the Lord counsel also produces the certificate of. Because of the photocopy is accepted, you cannot make a certificate of. So your order dated one is not order dated numbers.
एक न 25 সেটা তো আমি জবাব দিয়েছিল 1 ন 25
As of the last date, there also is dated and dated submitted that the opposite party has suppressed. Certainly suppressing will be posted.
नहीं पैसा हटन हुआ था
Suppressed.
13 भी आज वाला
The state aspect was earlier recovered in the order dated 23 to 26. They also counsel was asked whether he has produced any evidence that had appropriate artificial the building was fit the building CMA for 2025. Indicating not indicating substantiating the payment of rupees 2 lakhs by the petitioner and receipt of the same by the opposite party right in the match. In response, it submitted that the fact the application for the system 30B was filed on 20th law by both the parties. By the petitioner as well as the opposite party together. The same application was dismissed on 5/8/2044. The Lord clauses for the last in view of the categorical assertion that the amount of 2 lakh was paid during pendency of the proceeding on the 30th week, that is between 26/9/2023 and 5/8/2024. Whether the learned judge, the learned court which was in session of the said 30th application, the longer condition.
महिला हाँ 194
और 16 तक से बोला
नहीं नहीं ठीक है पढ़ 194
that is
194 2022
as recorded in any of its order regarding payment of the students and receipt of the amount of 2 lakhs by the wife is submitted there. This order nahi apna pucho in presence.
Again?
This order nahi 13 period was 13 period pendency.
Again.
This order dila recording statement and receipt.
ऑर्डर से तार अछि एडमिट हेछि कंसलेशन जायछि सब अछि
अरे ड्यूटी लिखा है सेक्शन पड़े वाला
नहीं सी एडमिट कले जे 13B टा एडमिट हेला
सर्टिफिकेट वो ना वो डायरेक्ट आंसर इज शोन saying that the opposite party in court has advocated that to be recorded hearing that unless your any court has recorded regarding admission of the opposite party regarding sale of the bond or the details of payments made of 2 lakhs as claimed by the petitioner bearing. This court cannot recognize the said submission to interfere with the CLA number 2 of 2025. That's all.
एडमिशन है जे एडमिट ऑर्डर टा दउथिबे अपन नेले
What is this process? I don't understand.
नहीं मैं
आप 25 कर रहे हैं जो सपोर्टेड पे एफिडेविट अपन आज ओडे चले लेकिन धीरे अपन को 50-40 मिनट है
आज्ञा
लेकिन धीरे को ऑर्डर टा हिट को ऑर्डर दिया
एडमिशन नहीं जिता मन
लेकिन धीरे जोटा कोर्ट ऑर्डर क्वेश्चन
कोर्ट टा एंटायर ऑर्डर सेटा कोर्ट एडमिट हेला पिटिशन टा पार्ट एंड पार्सल कोर्ट नहीं आज दिन कोर्ट जे तो एडमिट आज्ञा my lord
the second regulated by the petitioner those are having the application as a dismissed or terminated
Allah dismissed for default
dismissed for default or dismissed otherwise is different
I think different matter
how
dismissed for non-prosecution if a case will non prosecuted that is called dismissed for default
it is not even knowledge
I have some on merit one case this but the wording was trial court dismissed for default
somebody offered us to discussion. Yes, courtroom discussion. Legally was. What is the question?
You will not suggest your lordship. This is the wording.
That was submission. Yes.
When the wording you had mentioned in that order, so dismissed for default. I place before lordship the wording by the trial court. And dismissed for default.
That's consequence for I think that is different.
I think no, your lordship could be question that dismiss. I think on
dismiss for default for what
my lord.
Dismiss for default. When you consider this one after discussion of a petition, initiated under category of the Human Act, the legal consequences from the same dismissal or default cannot be that. The court has relied on the statement of one of the parties, that is the husband, that he had paid a peaceful acts to the wife. Well, no other independent material is not before this court. Not any order is passed by the current judge in the said petition during its pendency. If it was dismissed for default on past hierarchy with the choice. We submitted by the Lord Council of the petitioner that the Red Court would have proceeded to the present CLA. In view of the suppression of the fact of the 13B proceeding. From the perusal of the available ordership permission from this store, which Mr. Clear that emotional plea has been yet taken in the pending proceeding, that is serial number 02 of 2025. Regarding suppression of, in fact, particular payment if payments made if any in the not in the during pendency of the CP number 194 of 2020. That was dismissed before, not passed at the judge. But I think the review of the discussions made out of the issue will be very the memo connection with the executive. Because I start by subsequently interrupted. Yes. Yes, next.
Item number 16.
May I please advance? The appeal is against the order passed by the learned judge, Family Court, Keonjhar, in a petition on is refused.
So it is part of it. Part of it. Sure. Glad. What's going to be this issue by what? How do we take it? It's basically the chance.
Well, 24 रे ହେଇଥିଲା limitation limit. Hmm. 16/8/24
So that our data starting with the rules.
সেটা 30/2019 ডিলে কন্ডোনেশন নোটিস ହେଇଥିଲା সেটা ସେମାନେ ରିଫ୍ୟୁଜ କଲେ ତାପରେ ବର୍ତ୍ତମାନ ଅପିଲ ରେ ନୋଟିସ ହେଇଛି ଫ୍ରେଶ ଆଜ୍ଞା ମାନେ yes madam yes ଆଜ୍ଞା ସାର୍ଟିଫିକେଟ କପିଟା ବି ଅଛି ସେଇଟା 30/7 ପରେ ପୁଣି ଫ୍ରେଶ ନୋଟିସ ପରେ ହେଇଥିଲା ସେଇଟା ମୁଁ କହୁଛି issue notice to the respondent number 1 and 2 by registered post with AD indicating therein ମୋର ସାର୍ଟିଫିକେଟ କପିଟା ଅଛି order number 5 had Mr. Paningray and counsel for the petitioners none appears for the opposite parties in spite of valid service of notice. This is an application for condonation of delay in filing the appeal. Considering the reasons stated therein, the delay in filing the application is condoned. I disposed of. Done it. And there is any evidence of on record.
ପଳେଇଲା 45 ମିନିଟ ମାନେ on 2 days ଗଲା ଥର ଯାଇଥିଲା ଆପଣ ବର୍ତ୍ତମାନ ମୁଁ ଡାକିଲି ଯେ ନୋଟିସ ଯାଇଥିଲା 30/7/19 ଇସ୍ୟୁ ନୋଟିସ ସେଟା ଆପଣ ଅବଜେକ୍ଟ କଲେନି ଯେ ଆଜ୍ଞା କଣ୍ଡୋନେସନ ପାଇଁ ଯାଇଥିଲା 30/7 ରେ ଡିଲେ କଣ୍ଡୋନ ହେଲା
ଅପିଲ ରେ ନୋଟିସ
ସେଟା ହିଁ ମୁଁ ଡାକିଛି ଲେଖିଲେ 30/7/2019 directing observing that the matter is likely to be disposed of at the stage of admission. Notices were issued, though Time for further time was granted for filing of requisites by order dated 6/8/2024. ହେଲା 6/8/2024. Thereafter, notices were issued by registered post with AD to R1 and 2. On 18/10/2024, fixing returnable date 03.11.2024. ହେଲା Office note dated 27/11/2024 indicates that unserved notice to neki dekhideବେ kept below person. The appellate counsel for the petitioner referring to the said office note submits that the notice has to be treated as sufficient. View of the provision contained in so and so CPC and section so and so of General Clauses Act, notice on R1 and 2 shall be treated to be sufficient. अच्छा इतने से लेडी ना नहीं है
मतलब 2 जन जगह
both are lady
नहीं
opposite party
husband and wife of respondent 1 and 2, they're the maternal grandparents of the minor. The maternal
you examine this, there is no precedence, no case law on this regarding whether in these kind of matters police notice can be issued.
Yes, madam.
Matrimonial matter,
yes,
police notice. Now
madam.
Supreme Court has said issue police notice.
Madam.
Would have marked that. ये execution टा पूर्व matter टा रिसे पढ़े लेना अच्छी तो कोई से yes लेकिन से in view of the judgment the पूर्व टा insert करो in view of the judgment rendered by the Hon'Ble Apex Court in larger bench Rahul Shah versus so and so Jinendra Kumar Gandhi, which has been circulated to all the courts issuing guidelines for proceeding with execution cases. The learned judge family court so and so cannot be faulted with in proceeding with the execution. Yes. देखो तो जब पुलिस नोटिस ही पारी जस्ट एग्जामिन कोडी मिली वाला
yes madam I will
चांस नहीं होबो
आगे सेटा भी दरकार
कस्टडी रे पिलाटा अछि
कस्टडी अछि पिला वर्तमान 14 years तो करे it's a paramount consideration that minor of that so his opinion was not taken with court.
Those who are appellants here,
yes,
they are not also the natural
they are the natural petition number appellant number 1 is the father and 2 is the paternal grandfather, 3 is
paternal
the
grandfather father also natural.
Yes, father is the natural.
ଆଉ ସେପଟେ କଣ ମଦର
ସେଠି ହଉଛନ୍ତି
ବିନା ହଉଛନ୍ତି ମଦର
paternal grandparents ଅଜା ଆଇ ସେମାନେ
ୱାଇଫ ଚଲି ଯାଇଛନ୍ତି ନା କଣ
ୱାଇଫ ଚାଲି ଯାଇଛନ୍ତି
allegation against the husband
allegation against
498
yes 498 302
very difficult
yes so I will limit my submission to the extent only because now the boy is of
direct decision against the accused who is accused person.
Yes,
there can be a direct decision in favor that
so my only limited
case
yes my limited paper will be to the extent of visitation right.
Visitation contact right, have you prayed before the trial court and it has rejected?
No,
that's the problem.
There is an interim application
and contact right is different criteria.
Yes,
you have to make a prayer for that.
Well, interim
application, what you can do, it is only I am not disposing of.
Yes, madam.
I mean, no intention to score.
My lord.
You should take a leave from this court, which will be granted. Right now also I can grant it, that you will move the approach to the court for considering your prayer for vegetation and contact right. Without prejudice, that will be taken up. And if you do not want to prosecute this matter, that's a different thing. But during pending source, you can move the court for vegetation and contact rights. Because now this court, what I will adjudicate when there is no finding on that.
In the interim, my lord, during course of trial of the proceeding, interim application was filed and the respondents were directed to produce the child before the court below. And after repeated directions, once the child was produced before the court below, and there was interaction between the father and the child. Thereafter, the final judgment was passed.
Upon the contact, you have not claimed anything regarding contact and vegetation. I thought that there is interim order. When you started submitting, I thought that there was interim order for contact and vegetation.
Interim,
unless you make that prayer, the criteria for considering any natural guardian's right to contract is very, very wide. Hardly a court will interfere. Treated sufficient.
Next week,
sufficient. Matter is
next week.
Should I observe today that you want to transfer?
Next week, police that notice.
The problem is that a child now knows that his or her mother is killed by you. You are the accused. Trial court did not give you the custody. High Court, how it will give when there are direct decision on this? In such a scenario. A 14-year-aged child, because this Guardians and Wards Act said that the welfare of the child.
Welfare of the child is paramount consideration.
Apart from her or he's a boy or a girl. Pilada poor na jia?
Poor.
Apart from his understanding, he would have been fed many things.
Yes.
So then, and you are the accused now.
And also since childhood, the child is with the paternal grandparents.
That welfare will go against you. Vegetation and contact right, there is a possibility. There is no, battle lines have been. You make a prayer, object on certain grounds, court adjudicates.
Yes.
Guardians and Wards appeal, the appellate court comes into picture. But there is nothing on record for that. That you should have moved actually.
Yes, not that.
It is like colliding head on. You are under trial for killing the mother of the child. Now you claim that give me custody. And you fall flat on your face. You should have waited. You should have been more patient. At least the child would have grown up or something would have happened.
No, custody,
is the child a witness of the crime?
No.
No, that kind of regularity to the case.
No. And the paternal grandparents, the present respondent, they approach the honorable lower court for custody of the child. The present petitioners were the respondents before the lower trial court.
They got custody.
Yes, they were in custody.
Very difficult. Very difficult.
Because it is
a conclusion that a 14-year-old will not be impacted by staying with the whom he knows to be the accused. And in fact, getting acquitted is a different thing also. That's a very, problematic area. It's sensitive.
Yes.
The matter stands adjourned.
Your Lordship,
we listed for orders, for admission.
For orders.
That way, we commencing. About a short adjournment.
Short adjournment.
33-20-26. Yes, next.
Item number 17.
So rest of the matters, please have some work. So any specific date you want, just tell me. I will go page wise.
Pardon me, item number 29.
Please also accommodate. He is a trainee newcomer who he doesn't understand also. So that's why I am also operating, marking how many, like 16-3-86, 23-3-83, 33-41 matters. So when I am giving you dates, I am looking at that only.
That happened, my lord. This
Yes.
matter was continuously waiting before Lordship, my lord, but could not reach it.
But the family court may not put this matter for final hearing, final argument. But because of the last occasion, the council of the council.
So both of you sought for adjournment. When he suggested that let it be, so it's a fair submission because when the matter is before this court, why to hurry the matter there? ଆପଣଙ୍କର କେତେ ନମ୍ବର ଆଇଟମ ପେଜ 2 ରେ ଅଛି
29.
ମୁଁ ଯାଇନି ପେଜ 2 ରେ ସରି I thought that page 2 item any matter in page 2
25 that's
page 3 होची 23 रे कौन मेंशन करथिले से मिस दास where is she 23 रे आपण अछंती just kindly come forward ଆପଣ ମେନସନ କିଏ କଲେ ଯେ ଚାଲିଗଲେ ବୋଲି
We are appealing for OP number 6.
ପିଟିସନ ଚାଲିଗଲେ ବୋଲି ଆପଣ କହୁଛନ୍ତି
Petition side.
Sir, we are for the court number sub item 23. I'm appearing on behalf of my senior Lalitendu Mishra.
ଆଜ୍ଞା
Lalitendu Mishra.
ଲଳିତେନ୍ଦୁ ମିଶ୍ର ନାଇଁ ସେ ତ ନାହାନ୍ତି so that gets complicated no it has to be simply adjourned because I think somebody mentioned in the first matter Miss Das is present in the first matter she mentioned before rising
First and third, the petitioner is expert.
can I record that or no better let them be here
my lord item 23
yes
sub item second item
yes
I am for the
Prakash Mishra. You are there
yes lord
yeah
what happened my lord in first case the petitioner Shamsundar Agrawal died in the meantime so the petitioner has to take step for substitution
Sam S Agarwal
my lord Shamsundar Agrawal died in the meantime as per
item 23 लिखंतु first item Sam S Agar जोटा WPC 5199 of 2013 submitted by Miss Das Shraddha Das on behalf of the petitioner Mr. A Bera
Mr. Ratha senior advocate is appearing
no ताको junior जने सकाळे थिले मतलब I identified him
yes sir
he is I think SK Bera was SK Bera थिले और जो Miss Das थिले
हां Das
Miss S Das
Miss Das is appearing Miss S Das
Miss S Das for the petitioner anyone present in the first item
my lord sub item number 4
the first item रे
it's a confusion now सेटा problem let us not go into the in fact a wrong order will be passed
for the opposite side Mr. Jadipal and SK Mr. senior advocate is appearing
State so PK Mohanty, Additional Standing Counsel. For opposite parties 1 TO25. Anyone for OP number 6?
Lordship. On behalf of Jaypal.
आपन को नाटा?
Ranjit Mahapatra, Lordship.
Rajit Mahapatra. Ranjit. Mr. Ranjit Mahapatra on behalf of Mr. Jadip Pal for the OP6. It is submitted by Ms. Das Learned Counsel for the petitioner that the petitioner has passed away and the legal heirs are to be brought on record. Kiran Kumar Mahanti likhile? Yes. Brought on record. C6 adjournment. Accordingly, the matter shall be listed in the week commencing 6/4/2026 by the said date necessary steps be taken for substitution of the legal heirs of the petitioner. If any application is filed, the copy of the same said application shall be served on the all the parties. Second matter लिखंतु Mr. Prakash K. Misra for the second hochi WPC I-401 of 2013. Mr. Prakash K. Misra for the petitioner. So Mahanti, Prem Kumar Mahanti for the 1, 2, 4. Mr. Ranjit for OP6 5. In view of the order passed in the connected writ petition 5199 2013, the matter shall be listed along with the said matter on in the week commencing. In the week, yes.
Lordship, interim order to continue.
Sabura
No, Lordship only for 5199.
Interim order in the first matter.
5199.
My lord.
First matter re interim order as passed
5199
shall continue till the next date of hearing.
The third matter is
Third matter same order.
First item.
12847 of 2013. Order ta repeat ho gala 5199 same substitution kariya padibo. But last time ever फिर again in the order passed in connected that सेटा भी रही. Appearance same. Miss A. Das, Mr. P.K. Mahanti AC, Mr. Joydeep Pal. Your name, madam? Madam, yes, your name?
Sub item 4.
Yes.
A Sahoo on behalf of Mr.
Sahoo, madam ko na si mention करता ना. Again?
Vibhamay Panda.
Miss Vibhamay Panda and Mr. A Sahoo on behalf of L Misra for the petitioner. Corporation appear kale. Samir Misra
for corporation man.
35582.
Role is not there.
देखियो पूरे देखो सबुठी प्रदीप महांती को पे अपेयर करचोंती मिस्टर पाल এটা কর্পোরেশন পার্টি না এটা 35582 তো
35582.
Corporation party in Mr. Prem Kumar Mahanti for the opposite parties, plural. In view of the order passed in, so and so, that is listed. Yes, next. Items 24 to 28. 25. Kebe asle abo sir? Cover not made again. Kebe asle abo? Next week sir,
सरकार काउंटर फाइल करियोगा अपन लास्ट चांस कहथि आ पूर्व ऑर्डर थिला लास्ट चांस तापर
लास्ट स्क्वायर चांस नेक्स्ट है लास्ट गिफ्ट चांस एक्सपेंशियली बॉडी जीवो लास्ट
रिट्रैक्ट करि गेलेनी खाली से
अपन वीक कमेंसिंग कर दियम तो
5-7 मिनिट लागिबो
चेष्टा वीक कमेंसिंग 30 दिन
30
सर हमर तो एथरे ऑर्डर से प्रेस एडमिशन हियरिंग बहुत ही जाउची हो तोटा गुटे experiment going on by the court. But just application should not be kept pending. So say that.
The dismiss for default or dismiss तादर भी चलला.
हे चिता तेरे अपन को केस हेतला थरे तो रेस्टोर हैला फिर उतर हैला.
आज्ञा
सेटा से अब अच्छा से सेटा इंटरेस्टिंग. तो डिसमिस हैला पर कोन कॉन्सिक्वेंस मुझे बुझी पाले कॉन्सेप्ट ले.
ना बुझी हबन.
अच्छा बुझी हबन ठीक है
30 मिनिट खंड बसी की नते हाई फाई मारला सब कहले आ पारिबिनी ମୁଣ୍ଡଟା ବେଳେ ବେଳେ ଟିଣା ହେଇଯାଉଛି ଆଜ୍ଞା, କଣ କରିବେ ସେମ କଥା ଗୁଡା ଶୁଣିଲା
No, perhaps he wanted that the default word should be there. So সেটা move further ভাবে how it is different.
ଟିକେ ଚାହୁଁଥିଲେ dismiss for default and dismiss are different.
Consequence ତ ସେ
consequence ଟା
ସେ କହିଲେ, ମୁଁ ତ ପଚାରିଲି ତାପରେ ସେ ଆଉ କହିଲେନି. Anyway, that is how we are students of law. Once a student of law, always a student of law.
Always.
The great Nariman has said, and it's correct.
Let's see.
25 ଟା 30 ଦିନ ଭିତରେ ରଖିବେ ହେଲା.
Date fix କରିଦେବେ ସେ
Definitely ରହୁଛି.
ହଁ ସେ
Sir, it is working. Actually, it is working very well because at times ଯୋଉଟା କୋର୍ଟ ହଉନି କି ଧର 2 ତାରିଖ ଛୁଟି ଡିକ୍ଲାର ହେଲା, ଯଦି ୱିକ୍ ନ ହେଇଥାନ୍ତା ସେ ମ୍ୟାଟର ଲିଷ୍ଟ ହେଇପାରିନଥାନ୍ତା. Another so at least this is working by listing the matter in the week commencing, it is adjusted.
କେବଳ ଟିକେ ସରକାର ଅଛନ୍ତି କହିବେ ଖାଲି ଗୋଟେ ଅର୍ଡର ଟେ ପାସ୍ କରିବୁ ସେ କାଉଣ୍ଟର ଫାଇଲ କରିବେ
ସେଟା କରିବେ
5 ବର୍ଷ ହେଲା.
ଠିକ ଅଛି, but once I have stopped dictating orders, let us not do it.
All the ATL school and mass your lordship.
So the matter was mentioned. Please, item 23. The matter being list is mentioned by the Lord Counsel for the petitioner. Stating that the petitioner has passed away and requires 30 दिन आसू.
Your lordship, I have called the ADL school and mass, your lordship. I have intimated them regarding the counter to be filed. They will be acting upon.
No, I'm not passing any order, but please take note of the concern expressed by Mr. Naik.
Your lordship.
Yes. Yes. 26 yes.
Yes. So, Mr. There is a contractual teacher retired person ରହିଛନ୍ତି. Amount of the last occasion your lordship
Buildings were complete.
Buildings been they have not filed the counter.
I've made the
Mr. Sethi, again, this is after notice. And I think Mr. Mahanti or Mr. Patnaik mentioned one matter. He left. He said the counter not filed. So whenever a matter is listed for at least you find out how many cases, please take steps.
Your lordship.
Mr. Patra, item 26 जाओ 6-4. Already that little bit less number of matters. 6-4 की जाओ. Yes, next.
Item number 37.
No, 26 page wise.
No, ma'am. I'm on
29.
29, yes.
No, my friend is there.
Yes.
So
But he wants a date.
Any date? Interim order.
He says that let the trial court wait for at least this matter to be taken up.
That is the order dated 1912 notice.
Yes.
Lordship Mailer. So the coordinate bench of this Hon'Ble Court Mailer. The last occasion to the both parties mailer for mediation mailer.
Mediation failed.
Mediation failed mailer. And prior to that mailer, by the Learned Family Court mailer for a final argument of the case, CP. There. The last moment, the mailer of the opposite party mailer.
Mr. Tripathi, after computerization, there is a limitation for the court to take up the matters out of turn. Because if you mark, the after notice list starts with 2013. 13, then 17, then 20, then 21, then 22. So at least reasonably higher up in the list. That way. So that you should not have concern because it is being taken care of.
Your lordship also take into consideration the urgency of the case also directed for a listing it for orders mailer.
Orders problem. If as such there are some matters I am disposing of at the stage of fresh admission and orders after detailed hearing. There is one matter today that where the execution has been stalled despite Supreme Court direction. It was argued 45 minutes. Only on the point that whether you have deposited 2 lakhs, kindly show it here. Even if you have not shown there, you show it here. At least that gives me a handle to observe that since on so and so date this has been paid, the trial court will take the executive court shall take note of that. That order I could not achieve. That order would have helped the petitioner. I could not achieve because nothing is produced. Apart from repeating that, the facts have been suppressed. and the 13 petition is relied upon.
No.
No order. No, there in that case. I am saying how time is spent. That I should take up matters for list for orders. Then that doesn't solve purpose also. You take a date 29 in the week commencing. ଆପଣଙ୍କର ଯଦି ଚାହୁଁଛନ୍ତି କମ୍ I will tell you 16/3/86 ଟା ଅଛି 23/3/83 30/3/41 ଟା ଅଛି already posted matters other ହେଇଯିବ. So today you have 23/3 week ରେ 30/3 week ରେ 41 ଟା ଅଛି
33
ହଁ week ରେ ତାପରେ ଆପଣଙ୍କର 6/4 week ରେ 33 ଟା ଅଛି
ଏଥିରେ ସାର୍ ମେରିଟ୍ ସାର୍ କି ସବୁ ଇନଫର୍ମେସନ୍ ତାହେଲେ ସେଠି ଫାଇନାଲ ଅର୍ଡରଟା ହବ ଆର୍ଗୁମେଣ୍ଟ ପରେ ଫ୍ୟାମିଲି କୋର୍ଟରେ 21 ମସିହାର ଟା
ଫାର୍ଷ୍ଟ ୱିକ୍ ରେ ଛୁଟି ଅଛି that is another thing.
Take a chance, my lord.
6/4 କହୁଛନ୍ତି
6/4 ଟା ଲେଟ୍ ବେଶୀ ହେଇଯାଉଛି
ଆପଣ କେବେ ଚାହୁଁଛନ୍ତି କହୁନାହାନ୍ତି ମୁଁ ଆପଣଙ୍କୁ କହିଲି ଆପଣ ଶୁଣିଲେନି ବୋଧେ ମୋ କଥା this is your choice you have to decide between 16/3/86 ଟା ଅଛି 23/3/83 ଟା ଅଛି 30/3/41 କେତେ ସମୟ ନେବେ ତାହେଲେ ମୁଁ
ये लॉर्डशिप फिक्स रेट वाला
ଠିକ ଅଛି 30/3 week commencing 30/3/26
Intermediate, no intermediate is there.
Yes.
No.
Don't misguide the
No.
Sir, kindly see the order dated 19/12. Para 11.
The order dated 19/12 para 11 is reiterated and shall continue till the next date of hearing. ଏତିକି ଥାଉ ଅଧିକା କିଛି ଦରକାର ନାହିଁ that let the court wait for it is not prejudicing either of the parties.
Interim order my lord only to adjourn the matter for
correct ସେଇଟା ତ ସେ କହୁଛନ୍ତି adjournment ହବ ବୋଲି ଆପଣ in fact I said that but Mr. Bhuya said senior counsel said that is the order. Yes. 33 sir.
Yes.
33 ଆପଣ 6/4 ରେ ରଖନ୍ତୁ 6/4 ରେ 33 ଟା ଅଛି ଅଲରେଡି ଆପଣ ଲେଖୁଛନ୍ତି ତ ଯୋଉଟା ଡେଟ୍ କରୁଛି ଆପଣଙ୍କ କାମ ହେଲା ଲେଖିକି 33 week commencing 6/4 ମତେ ଲେଖିବେ item 21 ଟା ଦେବେ କମ୍ପ୍ଲିଟ ହେଇନି ତାପରେ ନେକ୍ସଟ ପେଜ
item 37
yes
I am also praying is sorted points
6/4 ରେ ରଖନ୍ତୁ week commencing 6/4 yes 38 yes
For a moment, Lordship's direction, nobody is appearing, but they are taking the maintenance amount. And sufficiency of notice already been.
Both are
Papa. Petitioner is the. No, I mean, only points. Short point involved.
Most likely better ଯଦି ଚାଲିଛି ନା କେହି dismiss ହେଇଯିବ
ନାଇଁ ସିଏ ତ ହବ
ବେଟର ଆପଣ ଯଦି ଦଉଛନ୍ତି ଚାଲୁ
ମାନେ ଅନରଲ କୋର୍ଟ କୁ ଅର୍ଡର କୁ ବି ଡିଫାଇ କରୁଛନ୍ତି ମାନେ ଏକ୍ସପେକ୍ଟ କରୁନାହାନ୍ତି ଧୋଲି ସେ ଆସିକି କହିକି ଯାହା କରିବେ ସେ ତ
ମାନେ ଏଥିରେ ଆପଣ ଯେ ଧନେଶ୍ୱର କହୁଛନ୍ତି ପୁଅ ଅର୍ଡର ଆପ୍ଲାଏ କରୁନାହାନ୍ତି
ନାଇଁ ଧନେଶ୍ୱର ଅଛନ୍ତି ପୁଅ ଯିଏ କି ପିଟିସନ ଅଛନ୍ତି
କରେକ୍ଟ ଆପଣ ତାଙ୍କ ପାଇଁ
ହଁ ମୁଁ ତାଙ୍କ ପାଇଁ
ଆପଣ ଦେବେ ଭ୍ରମଣ ପଇସା
ଆଜ୍ଞା
ସୋ ଭ୍ରମଣ ଏକ୍ଜିକ୍ୟୁସନ ଫାଇଲ କରିଛନ୍ତି
ସେଇଟା ଷ୍ଟେ ହେଇଛି ସବଜେକ୍ଟ ଟୁ ପେମେଣ୍ଟ वी आर पेइंग
ଠିକ ଅଛି
ହଁ ସେମାନେ ଏଫେକ୍ଟ କରୁନାହାନ୍ତି ତ ସର୍ଟ ଡେଟ୍ ରହିଲେ ସାରି ଦିଅନ୍ତା କେସ୍
once ଆସିଲେ I will be hit by execution stay ହେଲେ I will be hit by
ନାଇଁ ଏକ୍ଜିକ୍ୟୁସନ ଷ୍ଟେ ହେଇଛି ଯେ ସବଜେକ୍ଟ ଟୁ ପେମେଣ୍ଟ ହେଇଛି ତ वी आर पेइंग सर We are paying.
Have you marked that execution for Supreme Court guideline, the larger bench, 3-judge bench?
ସେଥିରେ କହିଛନ୍ତି ଯେ sub execution
that has been circulated to High Court. So I'll be hit by that. Already bulletin done ये.
ଗୋଟେ short date ରହୁଛି ମାନେ ଆସେ ଏଟା ଗୋଟେ dischargement.
Ganesh Gandhi or something. What I have just cited because that is Supreme Court has observed this.
Sir.
That in the process. There is lot of issue regarding the execution getting stayed and not getting over.
Right.
Law Commission, you are the bar, you are also criticizing. All of you, not that why execution is stayed. And it is told while reading CPC that the real case starts when execution is filed. like partition suits. The property will never be identified. So that is how Supreme Court has issued elaborate guideline. It rounds to some three pages in SEC. Rahul Shah versus Janes.
No, item 27.
Sir, I'll just go back. There is one mentioned matter is left. Thank you. Rahul Shah versus Jinendra Kumar Gandhi, 2021, 6 SEC 418. The larger bench, Mr. Mahapat. Yes. Sir, 27, 38 to 40.
I beg your pardon. Item 33, Your Lordship. Although I have filed the fresh wakalatnama on behalf of the petitioner, it has not been reflected. On the 24th, I have filed it.
33, since I am not taking up any matter in judicial orders passed, so unless it is mentioned, you are in place of Satyanarayan Mahapatra.
Yes. I am Satyaprakash Satpathy.
So it has to be Satya only, amongst Satya. The 27.
Which currency is 16 March.
27. So 16th ଅଛି ଆଜ୍ଞା 86 ଟା matter. 16th week ରେ 86 ଟା matter already posted ଅଛି. ତା ସାଙ୍ଗରେ ଅନ୍ୟ matter add ହବ.
23rd March.
23rd ରେ 83. 30 ରେ ଅଛି 41. But 30 ରେ ଗୋଟେ limitation ଅଛି ଯେ ଆପଣଙ୍କର ଛୁଟି 2 ଦିନ ଛୁଟି. ଠିକ ଅଛି ଆପଣ କେତେ କହିଲେ 16 ଦିନ ନା 23 ଦିନ କେବେ ଚଳିବ 16 ଦିନ 86 ଅଛି 8 ଆଉ 87 ହବ ଆପଣ ଆଉ ଯୋଉଟା ଆଗରୁ ଅଛି ଆଉ ଗୋଟେ ହିସାବ ବୁଝେଇବା ଯୋଉଟା ଆଗରୁ ଆର୍ଜ ନେଇଯାଇଛି ସେଟା ଆସିବ ନା କିଛି ଅନ୍ୟ ମ୍ୟାଟର ବି ଆଡ୍ ହେଇଯିବ ମେମୋ ଫେମୋ ହେଇକି ଆଡ୍ ହେଇଯିବ କିଛିଟା
interim order to be continued.
No, interim order is not touched. Interim order I am not modifying or touching any interim. I just wanted to take your opinion regarding posting dates. 27 ଟା 30 ଦିନ କରିଦେବେ
କେବେକୁ ଆସିବ ତାହେଲେ
पण 23 दिन କହୁଛନ୍ତି ନା 23 दिन 26 take your chance let us see what is that
Item 35.
sir 35 କେବେକୁ ଆସିଲେ ହବ
23 दिन
23 दिन କରିଦେବେ ଆପଣ ଲେଖୁଛନ୍ତି ତ
taken of the fresh admission case
no should not. And that creates separation that I am interested in Mr. Mahapatra's matter. I mean, I'm not taking your name, his name. So that way it should not happen. Your senior, Mr. Satpathy was moving that only. He said that his matter, though it is, when the High Court is only awaiting adjudication. That way, item 21 ne diyantu. Mention itla memo file. Yes, you take your seat. 21 is some TRP serial matter.
I was thinking, my lord, I am not available, my lord, that week, my lord, commencing from 30th. 30 say week, sir. ରହିପାରିବନି ତ 23rd sir ଟି କଲେଜ
अरे 23rd ଆପଣ ବା ନିଜେ ନେଲେନି ଜାଣିଲେ ଯେ 83 ଟା ମ୍ୟାଟର ଅଛି
ସେ ଆସୋସିଏଟ
ଆପଣଙ୍କର sir you have made a smart move if a matter is posted on a date where less matters are there it will automatically come up
23rd
ସେ ବଢେଇଲେ ମତେ ଲାଗିଲା
ସେ ଗଲେ କହିଲେ 30th
so ଆପଣ ଯୋଉଟା ଭାବିଛନ୍ତି ଠିକ ଭାବିଛନ୍ତି ଯୋଉ ଦିନ ନେଇଛନ୍ତି ଆପଣ ଯୋଉ ୱିକ୍ ରେ ସେଥିରେ 41 ଆପଣ 23 ରେ ଜଷ୍ଟ ଡବଲ ମ୍ୟାଟର ଅଛି so you have done the right thing ଆପଣ ଆଜି ଯେମିତି ମେନସନ କରୁଛନ୍ତି ସେ ମେନସନ ଏଟା ନିୟନ୍ତୁ I am not prioritizing ଆପଣଙ୍କ ମ୍ୟାଟରଟା ଆଜି 17 2013 so 5-7ଟା ମ୍ୟାଟର ପରେ ଆପଣଙ୍କ ମ୍ୟାଟର ଆସିଯାଇଛି it is quite reasonable
ମୁଁ ରହିପାରିବିନି ସେଇଥିରେ
ତାପରେ 6-4 କରିଦିଅନ୍ତୁ
ସାର୍ ଟିକେ ତା ଇୟରଲିୟର ଯୋଉ
9ଟା ମ୍ୟାଟର ଅଛି
ଯୋଉ ନ ପଡିବ 23
ପାଞ୍ଚଟା ଅର୍ଡର ଆଇଟମ 7 ଦେଖିଲେ ଏସବୁ ହେଇଥିଲା ଆଇଟମ 7 ଲେଖନ୍ତୁ ଆପଣ 5 ଘଣ୍ଟା ଯେତେବେଳେ ପ୍ରୋସିଡିଂ ଆରମ୍ଭ ହବ ଆଫ୍ଟର ରିସେସ୍ ଡାକିବେ ନହେଲେ ଏଗେନ୍ ଦିସ୍ ପ୍ରୋବ୍ଲେମ ୱିଲ୍ ଆରାଇଜ୍ Non-appearance for the petition of the matter is called twice over, once when it reached, and again after resumption of the proceeding. After recess. To grant further opportunity, the matter shall be listed in the week commencing 30/3/2026. Yes.